New Clause 27, Susan Murray.
Thank you very much, Dr Morrison. It's a pleasure to work under your chairmanship. This new clause 27 would repeal specified provisions of the Nationality and Borders Act 2022. It would enable replacements of large portions of the Act, specifically clauses on asylum, immigration control, age assessments and modern slavery, to ensure the upholding of the Refugee Convention and providing for safe and legal routes to sanctuary for refugees and helping prevent dangerous channel crossings. Thank you.
Thank you, Dr Morrison. The Liberal Democrat New Clause 27 seeks to repeal provisions in the Nationality and Borders Act 2022 passed by the previous Conservative government. By attempting to repeal Section 29 of the Nationality and Borders Act, the Liberal Democrats are seeking to prevent the government removing people, including criminals, to a safe third country. Rewind back to 2022, when 45,000 people, 45,000, crammed into small boats, flimsy rafts, teetering on the Channel's unforgiving waves, a swarm spurred by the hope of slipping through our borders, hammering coastal towns and stretching security to its limits.
Until,
of course.
did he really mean swarm in that context? It's quite emotive language.
I would, you know, hot air is required this afternoon, I think, in this room, and I intend to give it. Hammering coastal towns and stretching security to its limits until we fought back with the Nationality and Borders Act's third country removals. That helped the government deter crossings by 36% in 2023, from 45,000 to under 29,000. Not by chance, but by design, sending a message to traffickers and migrants alike that Britain's no soft touch, no guaranteed prize. Now the Liberal Democrats barge in with New Clause 27, desperate to repeal Section 29, to shred that deterrent and plunge us back into chaos, flinging the Channel wide open, not just to the weary, but to every chancer or every criminal. This isn't tweaking policy, it's torching a firewall, inviting all those to Dover's cliffs and Deal's shores, erasing every inch of progress we've clawed from the crisis. The Lib Dems owes hard answers. How many boats? 50,000? 60,000? The Albania deal delivered a masterstroke of border control, a pragmatic triumph that's turned a torrent of illegal crossings into a trickle through sheer diplomatic grit. Back in 2022, Albanians dominated the small boat surge, 12,000 strong. A relentless wave of young men lured by traffickers' £3,000 promises of easy UK entry, clogging Dover's processing centres and fuelling tabloid headlines of chaos. Then came our 2023 pact with Tirana, a no-nonsense agreement that flipped the script. Fast-track returns, joint police operations and a clear signal: Albania's safe and you're going back. By 2024, the results were staggering, with weekly flights now whisking deportees home. Each jet a nail in the coffin of smuggling networks that once thrived on our porous borders. This wasn't luck or loud threats, it was cold, hard execution, bolstered by UK-funded cameras on the Albanian-Kosovo frontier and Albanian officers embedded in Dover. Yeah.
Thank the Honourable Gentleman for giving way. I think he's somewhat overstating the impact of the policy on Albania, because actually it was after the initial agreement was signed that we saw the massive spike in numbers coming from Albania, and it had started to fall already before the communique was signed. So the correlation and causation arguments he's making on the Albania scheme don't add up at all.
What's effective? This reduced the number of people coming from Albania by more than 90%. Of course it was. Do you know what? If we could get a few more agreements like this, we'd be on the way there. It would be huge progress. It represented huge progress, and I think to suggest otherwise is wrong. It choked off routes before boats had even launched and had a real impact. With New Clause 27, hell-bent... Yep.
Would he at least accept that the Albania returns were largely due to large numbers of foreign national offenders, which is a completely different category of people than we're talking about either with this clause or this bill?
We would want to return foreign national offenders, that's really positive, but actually the number of people choosing to cross because of that deterrent effect went down, not by 10%, not by more than 90% less people arrived from Albania in small boats. That is huge progress. If we can replicate that elsewhere, I'll be a very happy boy, because we will see a huge impact on those crossings across the piece. With new clause 27 hell-bent on repealing that backbone, oblivious to how Albania's success slashed crossings, while Rwanda's threat kept smugglers guessing, if they prevail, every bilateral deal's on the chopping block. Imagine Albanian numbers roaring back to 12,000, then other current surges unchecked. This isn't progress, it's sabotage. A reckless bit to unravel a system that's finally biting back at the chaos. Do the Liberal Democrats not want to be able to remove people from this country who've entered illegally? Do they believe that anyone who is a national of a safe country should be able to seek asylum in the UK? Can Liberal Democrat members explain why this wouldn't create a massive pull factor to encourage people to cross the channel in small boats? The Liberal Democrats are also seeking to repeal sections 15 to 17 of the Nationality and Borders Act. These sections of the Act specify that the Secretary of State must declare an asylum claim made by a person who is a national of an EU member state inadmissible. Why would the Liberal Democrats believe anyone from the EU needs to claim asylum here? Picture this, if you will. A scene so utterly ridiculous, it strains the bounds of credulity. An EU citizen, perhaps some laid-back Amsterdammer, pedalling along the city's picturesque canals one sunny afternoon, tulips nodding in the breeze, then suddenly deciding to chuck it all, hop a ferry and pitch up on Dover's pebbled shores, requesting asylum as if Netherlands' orderly bike lanes and windmill-dotted horizons had morphed into a scene. I will.
This is a particularly theatrical prose that we're witnessing, perhaps for the first time. Has Boris Johnson got a new job as your speechwriter?
His writing seems to be going quite well at the moment. I don't know that I've got the cash for him. It's not asylum. You cannot pretend the EU's 27 nations, a vast tapestry of safe, stable, prosperous lands, France, Italy, Spain, Sweden, take your pick, each a bastion of peace and plenty, somehow warrant the same desperate lifeline we reserve for those fleeing real and genuine chaos. This is the same organisation that the Liberal Democrats supposedly want to build closer ties to. The Liberal Democrats also want the UK to grant asylum to people who come to this country, having already been in a country where they've claimed asylum and been granted asylum. Why are the Liberal Democrats encouraging people to cross the Channel when they already have asylum or can claim asylum in a third country, in a safe third country? Just like the Labour government, the Liberal Democrats want to remove sections of the Nationality and Borders Act that allow local authorities and public authorities to conduct an age assessment on an age-disputed person. As mentioned before, when dealing with the SNP, not wishing those who claim to be a child to be treated as an adult, as we've already discussed, every European country, apart from ours, uses scientific age assessment techniques, such as an X-ray of the wrist, although, as we've said, there are other methods. Over 50% of those claiming to be children were found to be adults after an age assessment in the quarter before the election. Without a scientific age assessment method, it is very hard to determine their age. With the horror stories we've heard in this area, why do the Liberal Democrats want to put the people of this country at risk and blindly allow unverified people into the UK? But let's now talk about a nightmare unfolding right under our noses. One the Liberal Democrats seem hell-bent on making worse. In quarter 1, 2024 alone, 560 adults, grown men with stubble, receding hairlines, and years behind them, had the gall to pose as kids, slipping through the cracks until scientific age checks, those wrist x-rays and dental scans every sensible European nation uses, caught them red-handed and stopped them cold. The Lib Dems, with a new Clause 27, want to axe those checks, rip out the one tool keeping us from dumping 25-year-olds, maybe older, into classrooms alongside children. This isn't some abstract risk. It's happened. It's real. Men in their 20s sitting at desks meant for teens, all because we've let sentiment trump science. It's not protecting children, it's endangering them. A reckless gamble that turns schools into hunting grounds and parents into nervous wrecks, all so they can pat themselves on the back for being compassionate. If they get their way, every classroom's a question mark. How many more 25-year-olds will slip through before the damage is done? What do Liberal Democrats think should happen if the authorities believe a migrant who is claiming to be under 18 is actually an adult? Do Liberal Democrats believe that these people should be placed in schools with school children? Again, it seems as though the Liberal Democrats want to strip the government of any power to control who comes to the country, which would see net migration drastically increased. But this cuts deeper than policy. It's about what people expect. And the Liberal Democrats' new Clause 27 pulls hard against that grain. Voters have signalled loud and clear, with 68%, nearly 7 in 10, backing tougher border controls in surveys. A call echoing from Dover to Folkestone, where residents live with the reality of arrivals day by day. That's not a passing opinion, it's a steady demand rooted in years of debate, from 2016's Brexit vote to 2019's landslide, for a system that prioritises their say. Thank you.
Minister.
Thank you very much, Dr Morrison. I don't know what the honourable gentleman had for lunch, but perhaps we should all try to see if we can find out and have some of it ourselves, and then we can all compete with the Poet Laureate and the virtuoso performance that we've just heard. However, I'm going to talk about the clause. This new Clause 27 is in respect of the Nationality and Borders Act 2022. The Honourable Member is proposing that numerous sections of the 2022 Act are repealed as part of this bill. And I should start by making clear that we are determined to restore order to the asylum system, so it operates swiftly, firmly and fairly and ensures that the rules are properly enforced. It's a financial necessity to deal with the backlogs that we've inherited, the perma backlog particularly, but also others, particularly in the appeals space, so that these costs don't continue to mount up at the expense of the taxpayers. And getting the system moving again is a very important part of what we've been doing. The Home Secretary acted rapidly following the election to change the law to remove the retrospective application of the Illegal Migration Act 2023, which allowed decision makers to decide asylum claims from individuals who've arrived in the UK from the 7th of March 2023. And there was previously a ban on that because of the duty to remove, which was never going to be sensibly put into effect. I'm not going to talk through every section of the Nationality and Borders Act 2022, but which the Honourable Lady wants us to repeal very, very large chunks of in this new clause. But I think I'm just going to mention a few of those, and I hope that she'll forgive me for not being completely talking about every clause. But the introduction of the National Age Assessment Board, for example, in March 2023 relies on a piece of the National Asylum and Borders Act that she would wish to be repealed. In the interim, from that Act coming into being, we've introduced the National Age Assessment Board and made it available to across the country, and it continues to offer significant improvement to our processes for assessing age, including creating greater consistency in age assessment practices, which can be very inconsistent in the way that the Merton assessments are actually practically delivered in different local authorities. Some are more experienced at it than others, some are better at it than others. The National Age Assessment Board creates a standard and a sort of a bar below which it's hard to go, and sets standards that, in age assessment that are very important. It improves quality, it ensures that ages are correctly recorded for immigration purposes. The Nationality and Borders Act 2022 also placed protections and support of the Council of Europe Convention for Action Against Trafficking in Human Beings on a legislative footing for the first time in the UK, which includes the right to a recovery period in the National Referral Mechanism, including during which potential victims of modern slavery and trafficking are eligible for support and are protected from removal from the UK. It provides the means to disqualify individuals, and I suspect this may be the bit that the Honourable Lady objects to, from protections of support on the grounds of public order or bad faith. But this is actually in line with Article 13 of the Convention itself. And so that part of the National Asylum and Border Act put that convention into UK law, and I'm quite surprised that she's suggesting that we should remove that. The Act also sets out the circumstances in which confirmed victims of slavery and trafficking may be granted temporary permission to stay in the UK. Going forward, the government will be launching a public consultation before summer recess on how we can improve the process of identifying victims of modern slavery. We will provide details on the consultation in due course. The Act also introduced the establishment of a clear two-limb test for assessing whether an asylum seeker has a well-founded fear of persecution, and raised the standard of proof which an asylum seeker must satisfy for certain elements of the test to the higher balance of probabilities standard. It's helping to ensure that only those who genuinely require protection are granted it in the UK, whilst those who do not qualify will be removed. The government is committed to restoring order to the asylum system, and this bill supports our aim in ensuring that the system operates swiftly, firmly and fairly, and the examples outlined demonstrate the practical benefits of keeping the Nationality and Borders Act 2022 on the statute book to support it. So it follows, Dr Morrison, that I don't agree that new clause 27 should be added to the bill.
Susan Murray.
Thank you very much, Dr Morrison, and thank you very much to the Minister for her clear outline. But the Liberal Democrats do want to enable replacements of large portions of the Nationality and Borders Act and ensure that we uphold the Refugee Convention. Thanks. Sorry, apologies. And so, yes, we wish to take this forward. Thank you.
New clause 27 proposed as on the amendment paper. The question is, the clause be read a second time. As many as are of that opinion say aye. Aye. To the contrary, no. 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 Division. Division in night.
Jade Botterill. No. Dame Angela Eagle.
No.
Will Forster.
Aye.
Becky Gittins.
No.
Tom Hayes.
No.
Katie Lamb.
No.
Martin McCluskey.
No.
Seema Malhotra.
No.
Margaret Mullane.
No.
Chris Murray.
No.
Susan Murray.
Aye.
Kenneth Stevenson.
No.
Mike Tapp.
No.
Matt Vickers.
No.
Joe White.
No.
Pete Wishart.
Aye. Ayes were 3, the noes were 13, so the noes have it, the noes have it. Unlock. We now come to new clause 29. Susan Murray.
Thank you very much, Dr Morrison. This new clause would make provision for leave to enter or remain in the UK to be granted to the family members of refugees and of people granted humanitarian protection. Through this clause, the Liberal Democrats seek to support refugee family reunion and facilitate exactly what my honourable friend for Edinburgh East and Musselburgh talked about, of helping people to integrate into the community and learn the language, make a home and work to contribute to society. Thank you.
Refugee family reunion.
Question is that new clause 29 be read a second time. Matt Vickers.
Thank you, Dr Morrison. Liberal Democrat new clause 29 requires that within 6 months of the date on which this Act is passed, the Secretary of State lay before Parliament provision for leave to enter or remain in the UK to be granted to family members of people granted refugee status and of people granted humanitarian protection. In this new clause, family members include a person's parent, including an adoptive parent, their spouse, civil partner or a married partner, their child or sibling, including adopted child, who is either under 18 or under 25, having been under 18 or unmarried at the time the person granted asylum left their country of residents to seek asylum. Further, it can be taken to mean other persons, as the Secretary of State may determine, having regard to the importance of maintaining family unity, the best interests of a child, or the physical, emotional, psychological or financial dependency between a person granted refugee status or humanitarian protection and another person. If these provisions were not already incredibly vague, the Liberal Democrats have included a clause which says other persons can be determined by the Secretary of State. This could obviously result in a huge number of spurious claims made by family members who will say they have a dependency on another person, so they must be allowed to come to the UK under this provision. We already have judges completely stretching the definition of right to family life under Article 8 of the ECHR, but the Liberal Democrat clause would be subject to even more abuse. Beyond the vagueness, new Clause 29 risks piling unbearable pressure on an economy already creaking under migration's weight. Each new family member, however loosely defined, brings costs. Housing, where shortages already top 1.2 million units. Healthcare, with NHS waits stretching past 7 million. And schools, where 9 million pupils squeeze into overstretched classrooms. The costs of supporting asylum per individual run into the tens of thousands of pounds. Multiply that by thousands of dependents under this elastic clause, and you're staring at billions more, siphoned from taxpayers who've already seen their council tax spike. The Liberal Democrats don't cap this. They fling the door open ever wider, ignoring how finite our resources are. Britain's compassion has no bounds, but its resources certainly do. Our generosity must have limits. New Clause 29 pretends otherwise, and working families will foot the bill when the system groans under the strain. This clause doesn't just invite claims, it opens a legal floodgate that could drown our courts in precedent-setting chaos. By letting the Secretary of State define family on a whim, emotional ties, financial need, new Clause 29 hands judges a blank slate to scribble ever wider interpretations, building on Article 8's already elastic right to family life. We've seen it, as we've mentioned, in an Albanian stayed because his son disliked foreign chicken nuggets. A Pakistani offender lingered, citing harshness to his kids. Now imagine dozens, hundreds of cases stacking up, each stretching dependency further. Cousins, in-laws, distant kins, all cementing new norms that bind future policy. The Lib Dems wouldn't just be tweaking rules, they'd be unleashing a judicial snowball that would roll over border control for years to come. Family unity sounds noble, but new Clause 29 sprawl could stall integration in its tracks, a challenge we can't ignore when 1 in 6 UK residents was born abroad, bringing in broad swathes of dependents, potentially with limited English skills or ties, risk clustering communities inward, not outward. Look across the Channel, Germany tightened family reunification after 1.1 million arrivals, capping it at 1,000 monthly for refugees kin, citing overload. We're not outliers for wanting clarity. Other nations prove it works. Yet the Lib Dems chase a boundless model, ignoring how allies balance compassion with capacity, leaving us to pick up the pieces when this experiment would fail.
Minister Seema Malhotra.
Thank you, Dr. Morrison, and thank you for the opportunity to be able to respond to this debate on new Clause 29. The Honourable Member proposes an amendment which seeks to significantly change the current refugee family reunion policy and expand the current eligibility to include siblings, children under 25, as well as any undefined family member. The government fully supports the principle of family unity and the need to have provision under the immigration rules which enable immediate family members to be reunited in the UK where their family life has been disrupted due to conflict or persecution. Accordingly, in recognition that families can become separated because of the nature of conflict or persecution and the speed or indeed the manner in which people may be forced to flee their homes, their communities, their country. Our refugee family reunion policy is an extremely important and indeed a generous policy. The route enables those granted a form of protection in the UK to sponsor their partner or child to the UK, provided that they formed part of that family unit before they sought protection. We have seen increasing numbers under this route, granted under the current policy and indeed under the previous administration. In 2024, almost over 19,710 people were granted family reunion visas. And this was twice as much as the grants in 2023, when there were around 9,300 visas granted. And coming to the specific proposals in this amendment and the expansion of the existing route, it should be noted that any expansion of the existing approach without careful thought, Dr. Merson, including where it allows an undefined family member to be brought to the UK, could significantly increase the numbers who could qualify to come here, and runs the risk of some abuse on those routes as well. This has an impact on the taxpayer as well, and could result in further pressures on public services and local authorities who may have to accommodate and support those new arrivals. Finally, with reference to child sponsorship, I think there's quite an important point to make here. We do believe that introducing a rule which allows children to sponsor their relatives would risk creating incentives for more children to be encouraged or even forced, because we know this can happen, to leave their families and risk hazardous journeys across the Channel in small boats, and have those journeys dangerous journeys to the UK. This is a very serious and legitimate concern, and is one which is in the best interests of the children.
Thank you to the Minister. It's good to hear that you do support the principle of family reunion. However, we would like to continue with this new clause. Thank you.
New clause 29 proposed as on the amendment paper. The question is that the clause be read a second time. As many as have that opinion say aye. Aye. To the contrary, no. No. Division.
Jane Botterill.
No.
Dame Andrew Eagle.
No.
Will Foster.
Aye.
Becky Gittins.
No.
Tom Hayes.
No.
Katie Lamb.
No.
Martin McCluskey.
No.
Seema Malhotra.
No.
Margaret Mullane.
No.
Chris Murray.
No.
Susan Murray.
Aye.
Kenneth Stevenson.
No.
Mike Tapp.
No.
Matt Vickers.
No.
Joe White.
No.
Pete Wishart.
Aye.
Ayes were 3, the noes were 13, so the noes have it, the noes have it. Unlock. We now come to clause 32. I call Matt Vickers.
Thank you, Dr. Morrison. We believe that the right to remain in this country is a privilege, not a right. We also believe that in order to be able to stay in this country, you must contribute to this country. As recent research by the Centre for Policy Studies has outlined, there's a risk that many of those who are coming to this country are either low-paid workers or have dependents who may or may not be working. Those individuals are likely to represent a long-term burden on the country's finances rather than being net contributors. This sentiment has been reiterated by liberal publications such as The Economist, which only last week said in one of its leaders, governments must also learn from policy mistakes that lend it credibility. Yeah.
I feel remiss for saying, not saying earlier, I do admire his tie, so it's a very nice tie. But on that point, is it not the case, as I've said consistently, that that particular report by the Centre for Policy Studies is flawed? But as we move towards the government's new net migration white paper, which will be specifying how you actually bring labour into the country that is skilled only, rather than the low-wage labour that we've seen under the previous administration, that there will not be that kind of a burden in the future.
So I aim to please with my tie, but actually I think when it comes to this policy paper, I think he would probably attach as much importance to it as he sees fit, as he does with anything else that I might not say. So I think it's for him and readers to determine what they're adding value to that and weight they add to that. I think one of the things that we're putting forward is around the salary thresholds, around what you should be earning in order to remain in this country. I think that's a big deal. I'll go on to outline why I think that's important, but yeah, I think it is a big deal. I think, yeah. Where were we? The Economist, which only last week said in one of its leaders, governments must also learn from the policy mistakes that lend it credibility. It was foolish to admit lots of newcomers without liberalising housing markets. Also, since migration flows to rich countries cannot be unlimited, it makes sense to favour highly skilled economic migrants over low-skilled ones nearly all the time. Arguments for low-skilled migration built around supposed labour shortages are flawed. Interestingly, in countries outside the UK, research has shown the importance of income in long-term migration. A report on the Netherlands, which used detailed microdata on fiscal contributions and benefits of the entire population to calculate the discounted lifetime net contribution of the immigrant population present in 2016, was published in December 24 and concluded if the parents make a strongly negative net contribution, the second generation usually lags behind considerably as well. Therefore, the adage, it will all work out with the second generation, does not hold true. High fiscal costs of immigrants are not that much caused by high absorption of government expenditures, but rather by low contributions to taxes and social security premiums. We also find evidence for a strong relationship of average net contributions by country with cultural distance, even after controlling for average education and the cyto distribution effect. While we should acknowledge that the Netherlands is a different country with its own unique systems, and that its situation does not necessarily apply to the UK, it highlights the need to examine the impact of migration decisions in comparable nations. This new clause takes steps to do that, ensuring migrants contribute to our economy.
Will the Honourable Member give way? Yeah. This is a very different Honourable Member that was speaking today and speaking last week, where I remember he spoke against and voted against the Liberal Democrat amendment to allow and encourage asylum seekers to work so they can benefit our economy. Does he not remember last week? Did he not want to, where was his concern of the taxpayer then?
That was quite a creative interpretation of last week's events. I think it's about what people contribute when they're here, when they're legally able to contribute, rather than creating anything that would draw more people to make that crossing to turn up in this country. A new clause 32 would revoke indefinite leave to remain in certain circumstances. These are that a person is defined as a foreign criminal under Section 32 of the UK Borders Act 2007, that the person was granted indefinite leave to remain after the coming into force of this Act, but has not spent 10 years resident in the UK. The person or their dependents have been in receipt of any form of social protection from HM government or a local authority, and the person's annual income has fallen below $38,700 for 6 months or more in aggregate during the relevant qualification period, or subsequent to receiving indefinite leave to remain. Let's be absolutely clear about one thing, because it's a cornerstone of this proposal that speaks volumes about who we are as a nation and what we stand for when the chips are down. Anyone who has entered this country under the carefully crafted, well-designed and wholly principled safe and legal routes, those lifelines we've extended through the Ukraine scheme, the British National Overseas scheme and the Afghan schemes, would find themselves entirely exempt from the rigours of this new clause 32, and rightly so, because they aren't just policies, they're promises, solemn commitments that speak to our national character, and we stand by those we've pledged to protect. Think of the Ukrainians, over 200,000 welcomed since 2022, fleeing Putin's bombs, families clutching what they had, offered sanctuary through the Ukraine Family Scheme and Homes for Ukraine. Yeah.
And looking at the proposals that's setting out in this, I thank you for giving way. How exactly would that 38,700 be how are you proposing to calculate that? Is there software available in the Home Office with HMRC? What if someone was found to have overpaid taxes and they were found not to do it? Would the Home Office go and find them overseas and bring them back? This sounds absurdly unworkable.
There are lots of processes in place that would allow, but actually we're putting a principle down on the line, the same as the skilled visa threshold, £38,700. You've got to make a line that requires people to be self-sufficient and not be a drain on resources. This is the line that we're setting. I'm just going to talk a little about Hong Kongers, nearly 180,000 British national overseas visas holders by 2025, escaping Beijing's iron grip. Huge British ties. And Afghans, 20,000 plus resettled since the Kabul airlift. These were the right things to do, and we would exempt them from this. There are random arrivals. These aren't random arrivals. They're people we invited, people whose stories of sacrifice and loyalty resonate with the values we hold dear, from duty to decency. We would not renege on those commitments and tarnish the trust that we've built. Let's cast our eyes out across the globe, because other nations aren't just theorising about this, they're proving it works. Day in, day out, with systems that don't just talk a good game, but deliver tangible, measurable results we'd be foolish to overlook. Take Australia, for instance, a land of vast horizons and sharper borders, where their points-based residency system doesn't mess around. If you're pulling in less than 53,900 AUD, that's £28,000 in our money, and you're dipping into welfare, they'll show you the door, an approach that's saving taxpayers billions. These aren't quirky outliers or flukes. They're lessons carved in policy stone, shining examples that tying status to contribution isn't some pie-in-the-sky dream, but a practical, proven playbook, one that delivers real savings and sharper borders, and that stands up to scrutiny. New Clause 32 lifts straight from that script, £38,700 as the line in the sand. No benefits to lean on, no criminal record to tarnish the deal. It's not radical, it's road-tested, and it echoes what works elsewhere on the globe. Critics might cry unworkable, but New Clause 32 conditions are trackable. HMRC already logs income for tax. The Home Office flags criminals under the 2007 Act. DWP tracks benefits down to the penny. We're not reinventing the wheel, just syncing data to enforce the rules, with £38,700 as a clear line. 10 years as a fair test, and exemptions for Ukraine, Afghan, and the British National Overseas schemes, showing we can tailor it. A framework that says if you're here for the long haul, you've got to bring something to the table, not just pull up a seat. When Australia and Canada have shown us the path with lower costs and tighter controls, we would be stupid not to take it. I'd like to know why the government would disagree with principles that this amendment is trying to achieve. I'd like to ask the Minister, why does the government want foreign criminals to remain in the UK with indefinite leave to remain? And also, if the government believes in the £38,700 amount for skilled workers to attain a visa, why would this not apply to people remaining in the UK indefinitely? Thank you.
Revocation of indefinite leave to remain in certain circumstances.
The question is that New Clause 32 be read a second time. Please, Bouchard.
Thank you. There was much Dr. Morrison. I wasn't going to rise to speak this amendment. I was just going to let the honourable gentleman drone on with the hope that we'd possibly get away on Thursday morning, but I've been irked to my feet. I'm not sure if I prefer the new loquacious honourable member for Stockton West. I don't know what he's done about his speech writing, but I prefer the version that we got last week. I think that was probably more in keeping with the Conservative contribution to the proceedings of this committee. But this is a horrible amendment which penalises lower income workers, deters skilled immigration and harms vulnerable groups. And the retrospective nature of some of the provisions is simply absurd, and it would only lead to legal challenges and all sorts of administrative complications. This amendment introduces retrospective punishments, taking away ILR from individuals who had received it under previous rules, simply because if it was ever a future government, thank goodness it will never be, would be this government later deciding to raise the bar. People make long-term decisions, buying homes, raising families, contributing to communities based on the stability of ILR. Changing the rules after the fact destroys trust in the whole system. And this proposal sets an arbitrary income threshold of £38,700, meaning a nurse, a teacher, a social worker, people in the UK depend on, could lose their ILR. And many industries, including healthcare, hospitality and retail, have workers earning below this level. Are we really saying that under no circumstances they would be welcome? It also ignores economic realities. People face job losses, illness or temporary hardships. Should losing your job also mean losing your right to live in the UK? This amendment states that ILR should be revoked if a person has received any sort of social protection, and that includes housing support. So what this does is punish people who have worked hard and contributed but need temporary support due to circumstances often beyond their own control. It targets families, disabled people and those facing financial hardship, effectively saying, if you need help, you don't belong here. Skilled workers, investors and entrepreneurs want certainty if they fear that a downturn in income or short period of hardship could see them lose their right to remain. They will choose other countries over the UK. And also, we've heard already, how can this be enforced? Constantly monitoring ILR holders' income benefits and job status would be an administrative disaster, costly, error-prone and unfairly target individuals. This amendment is simply cruel, it's unnecessary and it's unworkable, and I hope it is rejected out of hand.
Thank you, Dr. Morrison. We have spoken already today about ILR, or indefinite leave to remain, also referred to as settlement. We have already discussed the most basic requirement for eligibility, which is time, and our suggestion that that time frame be extended from 5 years to 10. This clause covers revocation, or the circumstances in which we believe indefinite leave to remain status should be removed from an individual to whom it has been granted. These conditions, as my honourable friend, the member for Stockton West, has set out, are: firstly, where a person has engaged in criminality. Our definition for criminality is based on that used in Section 32 of the UK Borders Act 2007, which is that a person is a foreign criminal if they are neither a British or Irish citizen and they are convicted of an offence where that conviction takes place in the United Kingdom and the period of imprisonment to which they are sentenced is at least 12 months, or if the person is a serious criminal, as defined in Section 72(4)(a) of the Nationality, Immigration and Asylum Act 2002. It is already the case that individuals with settled status can still be deported from the UK by having that ILR status revoked at the discretion of the Home Secretary. This amendment makes that process automatic. We can see no reason why a person who has committed a crime, particularly based on the current legislation, so serious that they are sentenced to a year in prison, should be able to continue to be in this country at all, let alone to retain ILR status and with it all the generosity and safety net of the British welfare state, including social housing, benefits and free healthcare. Secondly, we included in this amendment a condition which is effectively a knock-on effect from our earlier new clause 25, which would revoke ILR status conferred after this Act comes into force, where that status would not have been conferred under these new conditions. Next, those have been in receipt of social protection, as defined by the Treasury's Public Expenditure Statistical Analyses, which includes personal social services in various different categories, as well as incapacity, disability and injury benefits, pensions, family benefits, income support and tax credits, unemployment benefits, income tax, unemployment benefits, universal credit and social housing. Social protection is a fundamental part of modern British society, but we should be honest that it is also incredibly expensive. Such generous provision should only be available to citizens. It must be a fundamental principle of our system that those who come to this country contribute fiscally more than they cost. What they pay in tax should more than cover the costs of the public services that they use. That is the opposite of the situation we have now. Only a small proportion of those who have come to this country over the last few years are likely to be net lifetime contributors. This is unaffordable. This reality also underpins our final condition of income falling below £38,700 for 6 months or more in aggregate. This figure of £38,700 was chosen to sit alongside the general skilled worker threshold and the minimum earnings threshold for skilled worker visas and the minimum income requirement for a family visa sponsor proposed by the last government. This number was chosen as it represents the 50th percentile, or the median, of earnings for jobs at the skill level of RQF3, or level 3 of the Regulated Qualifications Framework, which is perhaps more easily recognisable as the equivalent of A-levels and BTECs. We believe these clauses will go some way to addressing the problems we have already set out today of the very high volumes of people coming to this country in recent years who are not set to be net fiscal contributors to the public purse over the course of their lifetimes, and we hope the government will consider adding it to the bill. We also welcome the comments from the Minister that she is looking at this. Could she please tell us specifically whether she is looking at any of these conditions, and if so, which? How are her discussions coming along, and when does she hope to report back to the House on her plans?
Thank you, Dr. Morrison, and I am pleased to be able to speak to the debate on Amendment New Clause 32. New Clause 32, which means that people who are settled in the UK will have that status automatically revoked in a wide range of circumstances. The amendment means that irrespective of any other relevant factors, such as how long a person has lived here, settlement could be automatically revoked where a person earns less than 38,700, has received benefits or would not meet requirements for settlement which subsequently changed. I think we've had some important contributions from honourable members across the House as to why this is in fact unworkable from for a range of reasons, and I understand why the government's seeking to bring this forward, and I understand that the opposition slip of the tongue. The opposition is seeking to bring this forward, and the honourable member, the shadow minister, seeking to continue his run of speeches with his new tie today in this committee session. But let me just lay out a couple of circumstances in which it would clearly show that this would be unworkable. It would create injustice in cases where people are settled and have been paying tax and national insurance contributions for decades, who could have their settlement revoked because they temporarily fall on hard times. Let's imagine, for example, a couple who have been here living together in this country for many years. A British man with his American partner. He gets badly sick, he can't work, she ends up having to look after him in local authority housing. And when he dies, I guess you're saying under your rules that she would be banned from settling in the UK, because that's the sort of circumstance that would logically follow. It's important to note as well that most migrants only become eligible to access public funds at the point at which they gain settlement, mainly ILR. The expectation is that temporary migrants coming to the UK should be able to maintain and to accommodate themselves without recourse to public funds. This approach does reflect the need to maintain the confidence of the general public that immigration brings benefits to our country rather than costs to the public purse. And I can understand that as an underlying driver for some of the debate today, but it is important that we keep this in the context of an immigration system that is fair as well as controlled and managed. And the no recourse to public funds policy is a long-standing principle adopted by successive governments. There is also an ability to apply for no recourse to public funds condition to be lifted in certain circumstances, so that there are safeguards for the most vulnerable in certain circumstances. But let me turn to the other core condition included in this clause, to revoke the ILR of a foreign criminal, and this was specifically referred to by the Shadow Minister in his speech. We've said before, we've said it all through this committee, that we believe that settlement in the UK is a privilege and not an automatic entitlement. This is because, as I've said before today as well, settlement does convey significant benefits, and it does provide a pathway to British citizenship. But settlement can be revoked for criminality, deception or fraud in obtaining settlement, or other significant non-conducive reasons. A person's settlement is also invalidated if they are deported. The government has been clear, in fact couldn't be clearer, that foreign criminals should be deported from the UK wherever it is legal to do so, and any foreign national who is convicted of a crime and given a prison sentence is considered for deportation at the earliest opportunity. I do just want to emphasise one point as well, which has been made by honourable members on particularly on this side, and that is in referring to the Centre for Policy Studies figures. It's worth just saying again that the figures in this report refer to a period of historically high levels of net migration under the previous government, and there's that and many reasons why they aren't a sound basis for evidence-based discussion. And I do think that it is, I will give way in a moment. She will, I'm sure, make the point that she made earlier, but she can certainly...
Well, yeah, no, you should finish first. I thank you. I thank the Minister for giving way. She is perhaps anticipating what I am about to say, which is we would very much appreciate in that case if she could instead provide evidential basis from the government upon which we could make some of these decisions.
I thank the honourable member for giving. Sorry, I thank the honourable member for her contribution, and I think I'll just make this point because she will know that we also have the upcoming immigration white paper on which we will be setting out our approach to the immigration system and how to support it to be better controlled and managed for the future. And that's because we are clear that net migration must come down. And she will know that under the previous government, in which she was also a special advisor, that between 2019 and 2024, net migration almost quadrupled, and that was heavily driven by a big increase in overseas recruitment. And a properly controlled and managed immigration system alongside strong border security is one of the foundations in the government's plan for change. And it is extremely important that we have a debate that is based around tackling those root causes, those root issues, rather than having a scenario in which we think we can tinker around the edges with a scenario in which the partner of a British citizen who subsequently falls ill and dies then has her ILR revoked. And I think there are important parts of understanding what we really mean in terms of people's lives and fairness in our society when the opposition brings forward amendments in this way. So the work to restore, I'm just wrapping up, but...
It was only to briefly say that I think we're actually starting to inch towards a more interesting debate which is being prompted by the opposition, which is that question of how do you assess the financial benefits and costs of migration and grounding that in available and high quality data. In Australia in 2021, the Treasury undertook a fiscal assessment and has on an annual basis repeated that. And I know too that the Migration Advisory Committee are looking to improve the quality of the data because we have over 14 years had such poor quality data in order to make assessments. I know too that they're starting to look at different category of workers in order to assess whether they are net contributors or net drags. And I think that's actually a really positive step. But I do really want to make this point that one of the reasons why we're relying on best or only reports is because we've had a government which really could have improved the quality of this data in order to make managed assessments of what controlled immigration look like that benefits our economy. But unfortunately, we've just had borders thrown open. We've had no sense of what our economy ought to be, no sense of what the skills ought to be, and that's just been absolutely regrettable. So would the Minister comment on the importance of the white paper to drive forward the immigration system that we actually need, grounded in the data that we need?
I thank my honourable friend for his contribution, and he highlights a very important point, which is about the importance of evidence-based policy making and the importance of good data. And I will say that good data across the whole of the immigration system was sorely lacking when we came into office, and indeed the utter chaos in terms of waiting, in terms of backlogs in every part of the system, just put huge pressures on and actually made it much harder to have information about, what was, where were the backlogs, who was in the backlogs, and actually trying to exert some control over the system and indeed important data to inform future policy. And he is right to point to the work of the Migration Advisory Committee that continues to do important work and also to engage with stakeholders and work across government. And they are an important part of the work we're doing to have a much better way in which we're using evidence to inform how we link skills policy and visa policy. And this work to restore order to our immigration system has been underway since we came into office. We'll be setting out our approach, as he has intimated, in our upcoming immigration white paper. So I thank you, Dr. Morrison, for the opportunity to explain why we don't believe this is an amendment we could support, and I respectfully suggest to the honourable member that he may wish to withdraw it.
Katie,
thank you, Dr. Morrison. I welcome the Minister's response, and particularly I think her words about the importance of settlement and citizenship and how important it is that that is earned. We on this side of the House are excited to see the immigration white paper and particularly any data and fiscal impact analyses it may contain. I apologise that this information is already publicly available and I am not aware of it, but could she tell us please when this white paper is due to be published? And could the Minister please also set out a scenario in which it would be preferable for a foreign criminal to remain in this country after having been convicted of a crime, and also please why she might consider that to be an unworkable amendment?
I thank the honourable member for her contribution. We have said we hope for the immigration white paper to be coming out later in the spring, and I have made some remarks in my speech in relation to foreign criminals, which is that the government is clear that foreign criminals should be deported from the UK whenever it is legal to do so. And any foreign criminal who is a foreign national who is convicted of a crime and given a prison sentence is considered for deportation at the earliest opportunity.
Thank you, Dr. Morrison. The Minister says that foreign criminals should be deported wherever it is legal to do so, but I think the purpose of our amendment is to make it always legal to do so. Why does she feel that this isn't something that would be helpful?
I thank the honourable member for her point again. I think I've laid out the arguments about needing to have an immigration system that is subject to rules, that can recognise different circumstances, and I've also laid out our point around foreign criminals and where it is legal to be able to deport them. That anyone who is convicted of a crime is considered for that, and I think she will also understand that there can be complexity in people's arrangements, and anything that becomes automatic in the way that she's described, I think needs to be subject to much more debate, certainly, than a new clause in a debate like this, where actually we aren't debating immigration, we're debating a system to stop the gangs and to improve our border security. And I think, you know, that's the space in which this, you know, it's important that we see through this legislation and for the purpose that it's been designed.
Anyone else? We feel strongly about the measures brought forward in the clause and would wish to divide on it.
New clause 32 proposed as on the amendment paper. The question is the clause be read a second time. As many as are of that opinion say aye.
Aye.
To the contrary, no.
No.
Division.
Division if not.
Jade Bottrell.
No.
Dame Angela Eagle.
No.
Will Forster.
No.
Becky Gittins.
No.
Tom Hayes.
No.
Katie Lamb.
Aye.
Martin McCluskey.
No.
Stephen Malhotra.
No.
Margaret Mullane.
No.
Chris Murray.
No.
Susan Murray.
No.
Kenneth Stevenson.
No.
Mike Tapp.
No.
Matt Vickers.
Aye.
Joe White.
No.
Pete Wishart.
No.
The ayes were 2, the noes were 14, so the noes have it, noes have it. Unlock. We now come to new clause 33. I call Matt Vickers.
Thank you, Dr. Morrison. Our new clause 33 aims to help the government by providing a way to put securing our borders above spurious human rights claims to frustrate removal. This new clause would disapply the entire Human Rights Act, as well as any interim measures of the Strasbourg Court. That would prevent the effective operation of legislation relating to immigration and deportation. The result would be that those seeking to appeal deportation or other immigration decisions would not be able to make human rights claims under the Human Rights Act in British courts. This amendment would apply this new power to all aspects of immigration control, including enforcement, deportation, the granting or removal of immigration and asylum status, or any other immigration entitlements. We'd expect Parliament to legislate and the Home Office to decide immigration cases based on their reasonable interpretation of the ECHR. But UK judges could only use UK law passed by Parliament to decide appeals, and no longer make expansive and common sense defying interpretations of what they claim the ECHR means. For non-immigration matters, the HRA would still apply, so UK judges could still continue to directly apply the ECHR there. We'll still be in the ECHR, so applicants can still go to the Strasbourg Court, but this new clause will stop UK judges expanding the definitions. In this scenario, people could also be deported pending a Strasbourg appeal, and we're repeating the Rwanda Bill measure to give ministers the power to ignore an ECHR Rule 39 interim order. We are not saying that this new clause provides the full answer to controlling our borders. Wider questions such as ECHR membership itself and wider immigration system reforms to be addressed in longer term pieces of work, but this new clause represents a step in the right direction. The reason that this amendment is necessary can be seen in recent decisions about immigration appeals. For example, an Iraqi drug dealer was saved from deportation from the UK after a judge ruled that he was too westernised to be returned to his home country. This man, who was jailed for more than 5 years after a conviction for dealing cocaine, had lived in Britain for 24 years and has a British-born daughter. Home Office officials attempted to have him deported, but a specialist judge in the Asylum Tribunal ruled that returning the man to Iraq would violate his human rights, as he would be viewed with suspicion. The judge said that the man, who cannot be named, would face persecution in Iraq because he would be seen as westernised. As we've already mentioned, an Albanian criminal who was allowed to stay in Britain partly because his son will not eat foreign chicken nuggets, an immigration tribunal ruled that it would be unduly harsh for the 10-year-old boy to be forced to move to Albania with his father owing to his sensitivity around food. The sole example provided to the court was his distaste for the type of chicken nuggets that are available abroad. Yeah.
I thank the Honourable Gentleman for giving way. I wonder if he would just assume we're familiar with these two cases now and either not bother citing them out or think of some new examples to support his
I
arguments.
think there are relevance. I think there are things that the public are bothered about, and there are things that I'm bothered about, and they show the failings of the system and why people are so concerned about the way it's going. As a result, the judge allowed the father's appeal against deportation as a breach of his right to family life under the European Convention of Human Rights, citing the impact his removal might have on his son. An attempt to deport a Sri Lankan paedophile convicted of assaulting 3 teenage boys was delayed over claims deportation would breach his human rights. The man was jailed for 5 offences. Yeah.
Is the Honourable Member more concerned about the Human Rights Act or the application of it by judges?
I'm concerned about the consequences for cases like this as a result of the Human Rights Act and its role therein. Yeah.
I didn't understand what he said. Is he more concerned by the judges applying of the Human Rights Act or the Human Rights Act itself?
I'm concerned in this context of this amendment about what the Human Rights Act means for these cases with regards to immigration, and that's why the clause proposes to remove its impact and disapply it.
I'm still not very clear, and I do apologise. I maybe ate too much at lunch, but does he have issues with the Human Rights Act such that he believes that we ought not to be applying that generally? Is this the first step towards a disapplication of that? Or is he more concerned that actually the legislation is fine, but we have in what seems a minority of cases here, judges that aren't applying it correctly? And could he also tell me whether what he's got here is a snapshot of cases that he's concerned about or the totality of cases that he's concerned about?
We've said about the relevance of disapplying the Human Rights Act, particularly with regards to immigration and the impact that it's having on these cases. I think I've been clear. You can read Hansard. The man was jailed for 5 offences of sexual activity with a child, but has been able to stay in Britain since 2011, owing to a protracted dispute over his asylum case. In 2012, the man, who cannot be named, was branded in court a danger to the community over his offences against boys aged between 13 and 15. He then applied for asylum by claiming his life would be at risk were he to return to Sri Lanka because he is gay. Since his initial application, his case has been through several court hearings as judges have assessed whether deporting the 50-year-old would breach his human rights. These are just 3 examples of how ever-expanding interpretations of the Human Rights Act have been increasingly frustrating the removal of those who objectively ought to be deported.
That was a helpful clarification to the question I put earlier, whether what he's citing there are a snapshot or the totality. He says they're 3 of the total number. How many in total has he looked at that cause him such alarm? And how many... Actually, I'll just leave that at that.
I think we allow those first-tier tribunals to go public. We'll be able to see a lot more. But I think these things undermine public confidence in the legal framework and the institutions that uphold them. And I think they're terribly wrong. Numbers, one too many of these cases, and actually happening in ever-increasing numbers. That's why we've brought this amendment. That's why he's going to have the opportunity to vote for it or otherwise. Our new clause represents a first step to restore some common sense to immigration appeals. New clause 33 steps up to wrestle back control from a judiciary that's wandered far from the reservation, turning the Human Rights Act into a sprawling, open-ended blank cheque for immigration stays, a carte blanche that's left us all scratching our heads at the sheer audacity of it. Last year alone... Yeah?
That's also a helpful clarification because his concern is around the judiciary and their behaviours. Can I just clarify that what he's just said there is exactly as I've heard it, which is his concern is purely about the judge's application of the Human Rights Act. He himself is absolutely fine with the Human Rights Act.
We allow our domestic courts to use it. We've created the framework, we've put it in place, and they do what they can with what's in front of them. I'm concerned about the way in which it's applied, but we need to change that if we want to impact the outcomes of those cases and those appeals. Last year alone, we saw far too many appeals built on Article 8. Family life flooding courts with ridiculously broad pleas. This Parliament is elected to decide the laws of the land. Judges are there to uphold that law. Yet they've morphed into border gatekeepers perched on high, second-guessing Home Office decisions with interpretations so elastic they'd snap any thread of reason. Family life ballooning to mean whatever they fancy on any given day. This clause yanks back that power to where it belongs, to MPs answerable to the people who elect them. New Clause 33 isn't just a legal tweak. It's a turbocharge for a deportation system bogged down by endless appeals, with removals stalled by Human Rights Act challenges. Each case drags on, costing tens of thousands of pounds per detainee in legal fees and housing, clogging detention centres already at capacity. Disapplying the Human Rights Act for immigration fixes the logjam, letting ministers and officials act fast, deporting those our domestic legislation was created to deport, freeing up resources for border patrols and visa processing that actually keep us secure. New Clause 33 restores public safety, a lifeline for a priority that's been fraying at the edges, unravelling thread by thread, as dangerous individuals exploit Human Rights Act loopholes to cling to our soil like barnacles on a ship. In 2024 alone, thousands of foreign national offenders, thieves, drug peddlers, worse, languished in UK prisons, costing taxpayers millions to house. Nowhere near enough were bundled onto planes and removed, leaving thousands to stroll out post-sentence, free to roam our streets because of Human Rights Act claims, tying our hands and deviating from Parliament's intended outcomes. New Clause 33 cuts through that mess. It means swift, no-nonsense removal of those who've shattered our laws, not endless hand-wringing debates over some nebulous right to stay that keeps them loitering in our towns. Public opinion, or the view of British law-abiding taxpayers, is clear. Nearly 3/4 call for foreign criminals to be removed. Yet here we are, the current setup letting threats foster when they should be gone. As the months go by, more of these bizarre judgments emerge, undermining public confidence in the entire system and our legal institutions. Let's take a tour beyond our shores, because other nations aren't fumbling in the dark. They're lighting the way, showing us this isn't some wild radical leap, but a steady, proven path that we'd be daft not to tread. France, for starters, increased its deportations by 27%, and has also seemed to be deftly sidestepping ECHR interim measures with domestic law overrides. 27% sent home. No faffing about with Strasbourg's Rule 39 edicts, just a clear-eyed focus on keeping their borders taut and their streets secure. And then there's Australia, where the Migration Act doesn't blink. Right claims bow to border control, and many are whisked out yearly with minimal fuss. The law created by those elected to do so determines who stays and who goes. These aren't rogue states, they're democracies, proud and pragmatic, balancing security with sovereignty. New Clause 33 strides right into that company. Parliament lays down the law, not Strasbourg's fleeting whims, echoing what's clicked abroad from Paris to Perth. I'd be interested in the Minister's thoughts on this proposal. In particular, if you think some of the recent examples of failed deportations are acceptable. We're apparently very familiar with Chicken Nugget Gate. If she agrees that some of these outcomes are unacceptable, but does not feel this approach is the way forward, how will the government end these cases that are making a mockery of our justice system and undermining public confidence in our legal institutions?
Orders legislation, Human Rights Act.
The question is that new Clause 33 be read a second time. Pete Wishart.
Thank you, Dr. Morrison. I'm compelled to rise again in opposition to what is probably the most egregious of all the amendments that we have to consider in these martial groups of the MS today. And I tell the honourable gentleman that's some competition which he's laid before us today, but I think looking at this one, this is by far the most disgraceful and appalling. Dr. Morrison, the Human Rights Act, it's an important guarantee. It's what makes us good world citizens and provides rights that are universal. It protects fundamental freedoms such as the right to life, the prohibition of torture and the right to a fair trial. And the Tories don't like it one bit. This right-wing nonsense that we heard from the honourable gentleman is a fundamental departure from the principle that human rights apply universally, not just to those that the government deems worthy. And it's a dangerous precedent, one that undermines the UK's long-standing commitment to justice, fairness and the rule of law. The Human Rights Act incorporates the ECHR into British law. Now, what the proposed Conservative amendment does would disapply the Act in immigration cases, effectively removing domestic judicial oversight and shifting the burden to the European Court of Human Rights in Strasbourg. And I was listening to the Honourable Gentleman very carefully, and I don't still know whether he thinks this is a good thing or not, because it's not taking back control. It's arguably about outsourcing decision-making to an international body, creating delays and legal uncertainty. It's also the case, and again I was listening to the Honourable Gentleman, we might get some more in his summing up in this amendment. This is a determination that would take decisions about immigration cases out of the hands of the judiciary and hand it to politicians. I can't think of anything more scarier. The Honourable Gentleman being in charge of determining asylum cases, and I think that's a prospect that would appall most ordinary people in this country. Now, the Leader of Opposition argues that some foreign criminals and illegal migrants are using the Human Rights Act to avoid deportation. And what we've just heard here is they want to dismantle human rights because of chicken nuggets. The idea that the entire human rights framework should be dismantled to address a few egregious cases is quite simply absurd. The Conservatives left the asylum system in chaos, spent hundreds of millions of pounds on their failed Rwanda scheme, and presiding over record-high small boat crossings. Now they want to strip basic rights from an already vulnerable group. The ECHR was established right after the end of the World War II to promote human rights, freedom and democracy. One of its driving forces was Winston Churchill, the wartime statesman revered by Conservatives and Brexit supporters as a symbol of British independence and self-reliance. And the UK was the first nation to ratify the convention drafted in 1950 and enacted in 1953, and it formed a broader set of commitments agreed by signatories to the 46-member Council of Europe, of which the UK remains a member despite its departure from the EU. Now, Dr Morrison, I agree, and I don't often agree with former Tory chairman, but I agree with Lord Patton when he said in his clear condemnation of this move, calling it absolute drivel. And the Conservatives Party's obsession with the ECHR and the will they, won't they leave it, we've never heard clarity on this yet, is little more than a political distraction designed to scapegoat supranational institutions instead of taking responsibility. It is dangerous territory, and I urge colleagues to make sure that this is thoroughly and rejected right out of hand.
Thank you, Dr Morrison. In November 2024, a Congolese paedophile who sexually assaulted his own stepdaughter was allowed to remain in the UK despite the government's attempts to deport him out of concern that forcing him to leave the country would interfere with his right to a family life. In December 2024, a Turkish heroin peddler was allowed to stay in the UK because it was ruled that deporting him would interfere unduly with his family life, despite the fact that he had returned to Turkey 8 times since coming to Britain. In February of this year, a Nigerian woman who was refused asylum 8 times was allowed to remain in the UK because it was decided that her membership of a terrorist organisation might make her subject to persecution in her home country. Earlier this month, a Nigerian drug dealer escaped deportation because he believed that he was suffering from demonic forces. Meanwhile, Samuel Frimpong, a Ghanaian fraudster, has been allowed to return to the UK after being deported 12 years ago after claiming that he is depressed in his home country. The list goes on and on. Absurd asylum rulings from our tribunal system seem to emerge on an almost daily basis. What do these cases have in common? In each one, a potentially dangerous person was spared from deportation because of our membership of the European Convention on Human Rights and, crucially, the domestic legislation which enshrines the Convention into British law, the Human Rights Act. This legislation is clearly not fit for purpose when it comes to managing and securing the border. It is enabling dangerous foreign criminals to remain in the UK putting the British public at risk. It is time that we recognise that decisions about asylum and immigration should be made by politically accountable ministers rather than by unaccountable judges and tribunals. That is the purpose of our amendment, which seeks to disapply the Human Rights Act and interim measures of the European Court of Human Rights in relation to this bill and to other legislation about borders, asylum and immigration. I will give...
Just to clarify, because I think she's saying very clearly that what she intends to do is to take decisions about immigration out of the hands of judges and leave it in the hands of politicians. Is that her intention?
I thank the member for his question. Yes, I think it is fundamentally important that these decisions about who can be in and who can remain in our country are made by people who are accountable to the public. I will make a little progress. The concept of universal rights is clearly a good one. It is one of the great gifts to humanity of the Judeo-Christian tradition to recognise that every human life has inherent worth, and every human being should be treated with the dignity that that inherent worth confers. But any set of rules that people may write over time can be distorted or abused, can be exploited to take advantage of our society, our kindness, the British impulse and instinct towards trust, tolerance and generosity. Our rules and laws on human rights and the organisations to which we belong that were created in the name of human rights should be subject to scrutiny and debate no less than any other rules and laws. Jonathan Sumption, Lord Sumption, former Supreme Court judge, has said that the United Kingdom's adherence to the European Convention on Human Rights raises a major constitutional issue which ought to concern people all across the political spectrum. It is right for us to interrogate our rules. Indeed, that is arguably our main job, the fundamental reason we have been sent here by our constituents. None of our laws should be above repeal, replacement or disapplication, and that must include the Human Rights Act. We are among the luckiest people in the world that we live in a democracy, I believe, that has the world's greatest people as its voters. And when the British people see repeated activity that contravenes our national common sense, politicians in Westminster must acknowledge that and must do something about it. If the government does not wish to disapply the Human Rights Act and interim measures of the European Court of Human Rights in matters of asylum and immigration in order to control the border and put a stop to the perverse cases and decisions we are seeing relentlessly arise in the courts, what is their solution? How will they restore common sense, fairness and the primacy of public safety to the security of the border?
Before I call the Minister, I just point out that Erskine May urges us not to be critical of judges in UK superior courts. I'm sure honourable members will wish to be circumspect in their remarks. Minister.
Thank you very much, Dr. Morrison. I'm not sure how much of the debate we could have heard had you made that observation at the beginning of it. I don't think this government wishes to join Belarus and Russia, the company of Belarus and Russia, as the people that aren't signed up to the European Court of Human Rights. The government's fully committed to the protection of human rights, and when we talk about human rights, that means all people who are human, everybody, applied universally. As the Prime Minister has made clear, the United Kingdom is unequivocally committed to the European Convention on Human Rights, and the Human Rights Act is an important part of our constitutional arrangements and fundamental to human rights protections in the UK, to start taking them away on a bit-by-bit basis, particularly to begin with people who are very, very unpopular, who have done difficult or bad things, could be the start of a very slippery slope if we are not careful. And therefore that's why I'm proud that our bill, the Border Security, Asylum and Immigration Bill, has printed on its front cover that it's compatible with Convention rights, and this government will always do things that are compatible with Convention rights. The paradox of some of what's being said in the debate we've just had is firstly that it politicises decisions, and that is a very different approach to judicial issues than we've seen for very, very many years, where in effect a lot of the powers on particular issues that used to sit with the Home Secretary have been taken by judges accountable publicly for their decisions, and I don't think that this government would want to see that reversed. And the paradox of the new clause that we're debating, new clause 33, would mean that all those who potentially had a human rights claim, whatever their circumstances, could go straight to the Strasbourg court, which would clog up the Strasbourg court. And as the Honourable Gentleman, the member for Perth-Rochester, pointed out, that's not taking back control in many ways, it's actually abrogating it and flooding the Strasbourg court with decisions that would have been sensibly taken here. Now, that does not mean, Dr. Morrison, that any individual one of us wouldn't be frustrated with particular individual decisions, but I would caution against using particular individual decisions that in some ways have only been partially covered or talked about on the front pages of the Daily Telegraph, which has been doing this, often taking decisions in cases out of context. And just, we've talked about chicken nuggets a lot, just to put on the record that that case is being appealed, and the judicial activities around that case haven't finished yet. So with that commitment to human rights and European Convention rights, I hope that honourable gentlemen opposite will, and ladies opposite will think about some of the potential consequences of what they're suggesting by chopping up human rights, by wanting to put us in the same company as Belarus and Russia. Think about the way convention rights were developed, and think about the positive, I will in a minute, and think about the positive things that adhering to human rights frameworks have actually given us as a democracy over the years. A good way to say, Honourable Chair.
In terms of these cases, I'm sure that some of the examples, she must disagree with some of the examples that we've seen. She must consider that it undermines public trust in the judiciary, in the legal institutions, the frameworks that we've got. But what is the solution? So have we got to grin and bear these appalling outcomes of these cases, or is there a solution? What does she propose as the way forward to stop these things happening?
Well, I mean, I respectfully say the Honourable Gentleman's party had many, many years to think of a solution themselves, and most of the cases that they're raising today actually had their genesis in the years that the party opposite was actually in power, and until close to the very end, as they became more and more frustrated, they then got to thinking about more and more outlandish approaches to this. Obviously, one wants the entire judicial process to be used, one wants it to be as speedy as possible, and if the government, the Home Office, wishes to appeal a particular case, it will do so. We keep a constant eye on these issues, and we think about reforms that we could put into effect, and obviously the Honourable Gentleman will be the first to hear about that if we decide to make changes. But what we don't wish to do is to abrogate from the Human Rights Act and the Human Rights Framework and the ECHR. That's where he and his party differ from us on this side of the House and other members of the opposition, which is why I don't agree with Clause 33 being part of the bill, and I hope that we will vote against it if the honourable members opposite insist on a vote.
Thank you, Dr. Morrison. I hope this was clear in my remarks, but I would like quickly to say, for the avoidance of any doubt or ambiguity, I have not, and on this side we do not, at any point criticise our judges. Indeed, as my honourable friend, the member for Stockton West, has said, they are doing the best they can with the rules and precedents under which they operate. That is why our amendment seeks to change those rules. Happily.
With the greatest respect, I think a reading of the Hansard transcript of what the Honourable Member for Stockton West said will be very contrary to what she's just asserted there. I don't think in any way, shape or form what the Honourable Member for Stockton West said could be described as complimentary of judges or supportive of judges. I think actually it was very undermining of judges.
I thank the member for his intervention. What my honourable friend, the member for Stockton West, very clearly said was that they are doing the best that they can with the rules and precedents that they've been set. I have described our judges as unaccountable to the public. That is not a criticism, it is a fact.
Thank you, Dr Morrison. The public are appalled by these cases. The member for Perth and Kinrossshire doesn't want us changing legal frameworks over chicken nuggets. If the Human Rights Act creates a situation where criminals, rapists and paedophiles are able to stay against the domestic law that's been put in place and its intentions, against the intentions of the people charged with making that law, then it's unacceptable. We feel strongly about this and wish to divide on the matter.
New clause 33 proposed as on the amendment paper. The question is that the clause be read a second time. As many as are of that opinion say aye.
Aye.
To the contrary, no.
No.
Division.
Division is right.
Jade Botterill. Dame Angela Eagle.
No.
Mr Will Forster.
No.
Becky Gittins.
No.
Tom Hayes.
No.
Katie Lamb.
Aye.
Martin McCluskey.
No.
Seema Malhotra.
No.
Margaret Mullane.
No.
Chris Murray.
No.
Susan Murray.
No.
Kenneth Stevenson.
No.
Mike Tapp.
No.
Matt Vickers.
Aye.
Joe White.
No.
Pete Wishart.
No.
Ayes were 2, the noes were 14, so the noes have it, the noes have it. Unlock. We now come to new clause 34, with which it would be convenient to debate new clause 42. I call Matt Vickers.
Thank you, Dr Morrison. Currently, a prison sentence of 1 year is required before a foreign national who is a convicted criminal can be deported. And even then, removal can be frustrated by asylum and human rights claims. Our new clause 34 would prevent a foreign national who is convicted of any offence from remaining in the UK, as well as anyone who's been charged with or convicted with an immigration offence under Section 24 of the Immigration Act 1971, and would disapply the Human Rights Act from these cases. We believe that the protection of British citizens is paramount and should be the overriding priority for government. If a foreign national has been convicted of any offence, they should lose their right to remain in the UK. There are a number of countries where the UK has a significant number of foreign national offenders. Yeah?
On that point, we agree. So why were they so tardy at actually deporting foreign national offenders when they were in office?
Well, we've just had quite a lengthy discussion about the Human Rights Act and the impact that that has on deportations, but I'm sure she might consider, if she agrees so wholeheartedly on the principle, she might consider backing our amendment. There are a number of countries where the UK has a significant number of foreign national offenders currently serving in British prisons. However, we deport only a small number of these foreign national offenders each quarter. Our new clause 42 would require the Secretary of State to use a visa penalty provision if a country is not cooperating in the removal of any of its nationals or citizens from the UK, or in relation to the verification of their identity or status. We've done this by amending the Nationality and Borders Act so that the ability to impose visa sanctions is not discretionary but mandatory. We know that there are countries that are hard to secure returns to. We believe strongly that this should not be without consequences for those countries. New clause 34 shifts the lens to where it belongs, onto the victims left in the wake of foreign offenders, not the perpetrators gaming the system. In 2024, theft offences alone averaging just 8.1 months. Each shopkeeper's livelihood dented, a pensioner's purse snatched, a family's peace of mind and sense of security destroyed. Public order crimes at 9.6 months, with more huge consequences for the well-being of victims, people left with a fear of entering their own public spaces or unable to go about their ordinary lives. Yet the 1 year deportation bar lets these culprits linger post-sentence, free to reoffend, while victims wait for justice that never comes. This clause says enough. Any conviction, shoplifting or worse, triggers removal, no Human Rights Act excuses, because every day a foreign offender is allowed to stay is another day a British victim's trust in the system erodes. Why is the government okay with that shadow hanging over our streets? New clause 42 will force nations to play ball or pay up. We see too many countries dither and delay in refusing to take back offenders. Mandatory visa sanctions flip that script. No cooperation, no UK visas for your elite. Watch how fast passports materialise when there are real consequences. Why is Labour soft-pedalling when we could wield this stick, clear the backlog and reduce pressure on prison places?
Offences and deportation.
The question is that new clause 34 be read a second time. Katie Lamb.
Thank you, Dr Morrison. This amendment, new clause 34, prevents any foreign national who is convicted of any offence from remaining in the UK. It should be a fundamental principle of our system that immigration never makes the British public any less safe. But unfortunately, many of those who have come to the UK in recent years have broken our laws. According to Ministry of Justice figures, a staggering 23% of sexual crimes, that is almost 1 in 4, in the UK are committed by foreign nationals. The overall imprisonment rate for foreign nationals is 20% higher than that for British citizens. Of course, this is not a uniform trend, and some nationalities are more heavily represented than others. Albanian migrants are nearly 17 times more likely to be imprisoned than average. Those from Algeria are nearly 9 times more likely to be imprisoned than average, and those from Jamaica nearly 8 times more likely to be imprisoned than average. Those who seek to harm this country, to break its laws, and to undermine what we hold to be fair and right should not be allowed to remain here. As the government is well aware, our prisons are already overcrowded. We must not allow foreign criminals to continue exacerbating this problem, and we must not endanger the British public by allowing foreign criminals to stay in this country. But under our current system, too many of those who break our laws are being allowed to remain in the UK. Often, Home Office attempts to deport foreign criminals are blocked because of absurd and ever-expanding human rights rules. In the interests of public safety, we must not allow foreign criminals to remain in Britain, and that includes by making sure that the Human Rights Act cannot be used to prevent us from deporting those who break our laws. How specifically does this clause do that? It amends Section 32 of the UK Borders Act 2007, which in fact we have already touched upon today. Section 32 of the UK Borders Act 2007 would be amended from its current form, which defines a foreign criminal as a person who is neither a British nor Irish citizen who is convicted of an offence where that offence takes place in the United Kingdom, and the period of imprisonment to which they are sentenced is at least 12 months, or if the person is a serious criminal as defined in Section 72(4)(1) of the Nationality, Immigration and Asylum Act 2002. What would replace it would be something much simpler. It would instead say that a foreign criminal is anyone who is neither a British nor Irish citizen who is convicted of any offence in the United Kingdom, and explicitly include within that anyone who has been charged with or convicted of an offence under Section 24 of the Immigration Act 1971, which sets out the situations in which a person can be considered to have entered this country illegally. This includes if they do so in breach of a deportation order, if they required leave to enter the United Kingdom and knowingly came here without that leave, or if they required leave to enter the United Kingdom and knowingly stayed here beyond the time conferred by that leave, among other specific conditions. Our amendment also seeks to ensure that these rules will be upheld in all circumstances, and asserts therefore that the principle of removing criminals from this country is of utmost importance and must be prioritised above other legislation, which includes human rights legislation, for the reasons we have already set out. New Clause 34 has been grouped with New Clause 42, but we will come to that subsequently. Debate that now. So I will now turn to New Clause 42, which requires the Secretary of State to use a visa penalty provision if a country proves to be uncooperative in the process of removing any of its nationals or citizens from the UK. This lack of cooperation may arise in verifying their identity or status, or it may pertain to the action behind the process of removing people whose identity and status has not been established. New Clause 42 seeks to do this by amending Section 70 of the Nationality and Borders Act 2022. That Act set out the idea of visa penalty provision, allowing the Home Secretary effectively to suspend visa applications from countries that do not cooperate with the activity the government is trying to take out to secure and protect the border. This amendment strengthens that bill by changing this from an option for the Home Secretary to a duty, and by adding explicitly this point about countries that are not cooperating with the process of verifying the identity or status of individuals whom we consider to be likely to be nationals or citizens of the country in question. I give way.
I struggled to try and understand this amendment when I saw it being presented. There's a number of reasons why other countries can't cooperate with the UK when it comes to immigration and visa cases. It could be political instability, there could be a right-wing despot who's in charge, but this impacts on ordinary asylum seekers. Does she not understand that there's a number of political reasons why that's the case, or even administrative reasons why they're not always able to cooperate? Can she accept that?
I thank the Honourable Member for his intervention. This retains the ability for the judgment of the Home Secretary to be used to determine whether or not a country is being uncooperative. If they are unable to help, then that is different from being uncooperative in the way that we would define it here. Happily.
I thank the Honourable Lady for giving way. There seems to be a volume of information just coming at us now, and I've got to be honest with you, it feels like every 20 words something is being said which is absolutely absurd. And it's a marked contrast with what has gone before. And I think I'm seeing the Honourable Lady and I'm seeing the Honourable Member standing, but I'm actually hearing the voices of other people in her party and his party. And this feels very peculiar right now. But I've got a specific question, which is, quite apart from the fact that the Conservatives effectively decriminalise shoplifting, if an Albanian national is convicted of shoplifting but cannot be deported to Albania, is she saying that she would have a visa penalty against Albania if they will not accept that shoplifting Albanian national, quite apart from what that might do for the wider relationship between Albania and the UK in terms of deportations?
I will happily come to the second question in a second. I thank the member for his intervention, but I am a little confused. Is he suggesting that I didn't write the speech myself?
Yes, actually.
Oh, well, in that case, I'm happy to reassure him that I wrote every word. But yes, is the short answer to the question about Albania. We absolutely would think that it would be completely appropriate. Why would Albania, as a country, refuse to accept one of its own citizens that should, by our rules and our laws, be returned to that country? If they refuse to do so, then we would consider that to be something absolutely that would trigger this, and appropriately so. To continue what I was saying earlier about new clause 40 and the way that it amends section 70 of the Nationality and Borders Act 2022, it also expands the Act to ensure it covers both nationals as well as citizens. We consider that it should be a basic and fundamental principle that we should be able to remove from this country those who break our rules. This is harder than it perhaps might sound, particularly when individuals are determined to lose their documents and obfuscate their identity and origin in every way they can. What we are proposing here will align the incentives of other countries with our own. It will create substantial pressure on other nations to cooperate with us to secure our border, and we strongly hope that the government considers adding it to this bill.
Minister.
Thank you very much, Dr. Morrison. This group of proposed new clauses 34 and 42 is a slight reprise of some of the debate we had in the last group of amendments, but also goes on to the visa penalty idea that, as the Honourable Lady, the member for Weald of Kent, has just explained, is encompassed in clause 40 and new clause 42. New clause 34 seeks to extend automatic deportation to any foreign national convicted of an offence in the UK or charged with an immigration offence without consideration of their human rights. We dealt with some of that in the last debate. It removes protections for under 18s and victims of human trafficking. It seeks to extend the automatic deportation provisions to certain Commonwealth and Irish citizens who are currently afforded exemption from deportation. I don't believe these amendments would be workable and are unrealistic and would undermine our international obligations. We already have the power to deport any foreign national on the grounds that it is conducive to the public good, regardless of whether they've had to serve the 12-month prison sentence that the 2007 Immigration Act requires. If they are if they are subject to a 12-month prison sentence, Dr. Morrison, it's a duty to deport them. Now, listening to the honourable members opposite, and the honourable lady was a special advisor in the Home Office, so she knows about these things. The honourable gentleman, a spokesperson in the shadow Home Office team, they're talking a lot about deportations, but they didn't, it has to be said, do a lot about it when they had the power. In the aftermath of the general election on the 5th of July last year, by the end of December, the new government had actually had a 21% increase in enforced deportations of foreign national offenders, some of them direct from prison, most of them, Dr. Morrison, direct from prison. But we also had to look to see the legacy that we were left. And that included, at that time, close to 18,000 people who were time-served foreign national offenders, who'd done their time in jail, been released, and were running around in our communities. Now, clearly, this is a big backlog that we have to try to deport, and whatever the protestations of honourable ladies and gentlemen opposite, they didn't try hard enough to deal with deportation in these cases, and it's certainly the case that a lot of those foreign national offenders haven't ever got to the stage where they've made human rights claims against being deported. They simply haven't been picked up and deported by immigration enforcement because the party opposite took their eye off the ball. We don't think, apropos of New Clause 34, that it would be proportionate to deport a person for a single minor offence, which is what the New Clause 34 says. I mean, a single minor offence could mean not having a TV licence, for example. Are we really going to be wanting to deport people for not having a TV licence when the party opposite couldn't deport nearly 18,000 people who are time-served national offenders who are in our communities even now, some of whom have committed serious offences, when there's a legal duty to deport them? So introducing a clause which increases the number of people that we are required to deport when they've singularly failed to deport the national offenders that have actually been jailed during their time in office seems to me to be protesting too much about their legacy and not dealing with the realities. So these amendments don't prevent persons being deported from raising human rights claims to the European Court of Human Rights. They'll deliver nothing except the outsourcing of our deportation considerations to Strasbourg, a bit like the last group of amendments we talked about, and that will slow down the removal of those being deported. The amendment would undermine our obligations to identify and support victims of trafficking, set out in the Council of Europe Convention for Action Against Trafficking in Human Rights, of which we're a signatory. This clause seeks to amend key immigration offences set out in Section 24 of the Immigration Act 1971, so there's no requirement to prove knowledge. It's likely that such amendments would be subject to ECHR challenge, resulting in delay and fewer successful prosecutions, and therefore fewer deportations. New Clause 32 also seeks to amend the Illegal Migration Act by 2023 by disapplying the Human Rights Act 1998 from key immigration legislation. We've just decided in the last group that we don't want to do this, and it's a technical point, but the amendments relating to the Illegal Migration Act in 2023 would have no effect and are redundant because this bill will actually repeal these provisions of the Illegal Migration Act. The focus of the Honourable Lady for Weald of Kent opposite is clear: to ensure that foreign national offenders are deported from the UK at the earliest opportunity. I agree that we should actually be doing this, and in fact we've had a 21% increase in the number of enforced deportations of foreign national offenders in the first 7 months that we've had in office. But this amendment won't further the cause because it risks actually slowing down removals. This government's focusing on the enforcement of the immigration system, increasing returns, and using this bill to create new powers to enable more effective controls around individuals who pose a threat to the public, whilst deportation is pursued, and we will continue this work. Turning to New Clause 42, we've been clear that the swift return of those with no right to be in the UK forms a key part of a functioning migration relationship. That's why 19,000, and it's over 20,000 now, I think people have been returned since we came into office. My officials and I have been working hard to strengthen relationships with our international partners to this end. For example, on a recent visit to Iraq, the Home Secretary signed a joint statement on migration. This included further work on the returns of people who have no right to be in the UK, where returns are currently very slow, and the continued provision of reintegration programmes to support returnees. Where cooperation with countries on returns falls below the levels of expected, and where appropriate, we use all levers available to us, including visa penalties, including having meetings with the appropriate ambassadors and telling them that if things don't improve, then visa penalties will be coming along. It does no good to require the Home Secretary to introduce visa penalties when that is a penalty that we can use if we get no cooperation whatsoever. And the Honourable Lady should be under no doubt that those sorts of penalties will be used if we think that it would have a positive effect on cooperation. Those listening to these debates may not realise that deporting somebody isn't easy. You have to get an emergency travel document issued. In order for that country to issue an emergency travel document, they have to accept that the person concerned is one of their citizens to begin with. And so that kind of identification takes time, and it's important that we try to cooperate with our international partners so that we can make this process as quick and efficient as possible, rather than going to war with our international partners and alienating them. But the Honourable Lady should be in no doubt that should visa penalties need to be threatened or indeed introduced, we would certainly do it. The existing provision in the Nationality and Borders Act 2022 gives the Home Secretary sufficient scope to be able to use visa penalties if assessed to be appropriate. The last government introduced these powers but exercised their discretion not to use them, despite obviously having returns challenges. And this government intends to retain that discretion to use the powers in the right way at the right time, so they will be effective to the maximum. We don't need a clause on primary legislation to require the Home Secretary to do that in all circumstances, regardless of the context and regardless of an assessment as to whether this would make things worse or better. And so the fact that this amendment aims to remove the discretion to decide whether to use the powers or not is inherently flawed. It's not something that the party opposite sought to do when they were actually in government. It's not something that the Honourable Lady opposite, as a special advisor in the department we're talking about, seems to have pushed then. It's no immediate way to discern whether a government is cooperating or not. That in itself is a discretionary judgment which would have to be taken by ministers in each particular context. Visa penalties have not been used before. In each case where the use has been considered, we've been able to successfully unblock cooperation through other means, such as ministerial and senior level engagement, of which I myself have done some, I can tell the committee. The provisions already provided for in the NABA are therefore sufficient for our primary aim of these powers, and I urge honourable gentlemen and ladies opposite not to pursue these new clauses.
Thank you. We wish to divide on this.
New clause 34 proposed as on the amendment paper. The question is that the clause be read a second time. As many as are of that opinion say aye.
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 Contrary, no.
No.
Division.
No.
Jade Botterill.
No.
Dame Angela Eagle.
No.
Will Forster.
No.
Becky Gittins.
No.
Tom Hayes.
No.
Katie Lamb.
Aye.
Martin McCluskey.
No.
Stephen Malhotra.
No.
Margaret Mullane.
No.
Chris Murray.
No.
Susan Murray.
No.
Kenneth Stevenson.
No.
Mike Tapp.
No.
Matt Vickers.
Aye.
Joe White.
No.
Pete Wishart.
No.
The ayes were 2, the noes of 14. So the noes have it, the noes have it. Unlock. We now come to new clause 35, with which it will be convenient to debate new clause 39 and new clause 40. I call Matt Vickers.
Thank you, Dr. Morrison. Our new clause 35 would require the Secretary of State to specify a cap on the number of spouses or civil partners who may enter the UK and on the number that may enter from any one country. It would also amend the immigration rules to set a salary threshold. We know that there is abuse of the current provisions that allow spouses or civil partners to come to the UK, and our amendment is designed to tighten up the rules so as to make abuse less likely. We believe it's important for the Secretary of State to set a cap for the number of people who can enter the UK as a spouse or civil partner, and that the number of persons from any one country who enter as a spouse or civil partner of a sponsor cannot exceed 7% of the maximum number specified. We'd seek to tighten up this route to enter in the UK by ensuring the applicant provides evidence that the parties under subsection were married or formed a civil partnership at least 2 years prior to the application, ensuring each of the parties intends to live permanently with the other as spouses or civil partners, and the marriage or civil partnership is subsisting, the salary of the person who has a right to abode in the UK or indefinite leave to enter or remain in the United Kingdom equals or exceeds £38,700 per year, ensuring that people are not able to sponsor their first cousins under this route. We believe these changes are necessary to ensure the relationship is genuine and subsisting, and that the sponsor is able to support their partner once they arrive in the UK. This is part of ensuring that we treat living in this country as a privilege, not a right, and that those coming to the UK to live will contribute to our country. Our new clause 39 would place restrictions on the granting of visas and indefinite leave to remain. This is another change to achieve our objective that those who come to the UK are able to contribute. This new clause would ensure that visas are only granted where an applicant or their dependents will not apply for any form of social protection, including housing, from the UK government or a local authority, and where the applicant's annual income must not fall below £38,700 during the relevant qualification period. If either of these conditions fail to be met, then the visa will be revoked. This new clause also specifies that a person cannot qualify for indefinite leave to remain where they are a foreign criminal under Section 32 of the UK Borders Act 2007, if they or any of their dependents has been in receipt of any form of social protection from the UK government or local authority, and where a person's annual income has fallen below £38,700 for 6 months or more in aggregate during the relevant qualification period. New Clause 39 does not apply to those who have come to the UK through the Ukraine, Afghan or BNO schemes. New Clause 40 would introduce some accountability for this place in the overall numbers of migrants coming to the UK per year. It establishes a mechanism whereby Parliament will approve a binding cap on all non-visitor visa routes set out by the Secretary of State. We believe it's important that this House seriously considers what the benefits and trade-offs are to this country, and our amendment is designed to give this House a greater accountability for that decision. New Clause 35 and 39 build a wall against the quiet epidemic of immigration fraud that's been seeping through our spousal and visa routes. Think sham marriages brokered for £10,000 a pop, or visa overstays masked by flimsy claims of support. The 2-year marriage rule, £38,700 threshold, and no first cousin clause aren't just hurdles, they're detectors, rooting out paper partnerships before they drain us dry. These clauses anchor immigration to a bedrock of self-reliance, because a Britain that thrives doesn't prop up newcomers who can't stand alone. New Clause 35's £38,700 sponsor salary, matching skilled worker routes, ensures that thousands of spousal entrants yearly don't tip the welfare scales further. New Clause 39 doubles down, barring visas and indefinite leave to remain for anyone dipping below that or tapping social housing, where 1.2 million people are already waiting. This isn't exclusion, it's economics, tilting the balance toward those who lift us, not lean on us. New Clause 40 isn't just a cap. It's also handing this House the reins of a migration system. This clause makes Parliament the arbiter, arbiter, a binding cap, debated here, voted here, owned here, and fully held to account by the electorate.
Restrictions on visas for spouses and civil partners.
The question is that new clause 35 be read a second time. Katie Lamb.
Thank you, Dr. Morrison. There are few things in life and in human nature more powerful than the desire to be with those you love. To be separated from your husband or wife by a national border is no small thing. Indeed, for those it is happening to, it can feel like everything. But the role of government is to determine what is right for the country, not for any one person, couple, or family. We must place this discussion in its national context. For too long, immigration has been too high, and increasingly the spousal visa route is being used as a route for those who would otherwise not be able to come to Britain. Over the past few years, we have seen the number of dependent visas balloon. As of December 2024, 51,000 migrants came to Britain via the health and social care route, bringing 130,000 dependents with them over the previous year. That's more than 2.5 dependents per health and social care worker. Dependents who will access public services, including our already overstretched NHS, in their own right. The dependent route for health and social care visa holders has since been restricted, but I mention it here because it indicates the huge level of demand and desire there is for family members to come here to Britain. There is much more to be done across the immigration system to ensure that the dependent route is not abused by those who are unlikely to make a contribution in their own right. Our lax rules around spousal visas are also exacerbating problems around assimilation. Currently, our system has no safeguards against forced marriages or against sham marriages. There is a culture in some communities of bringing vulnerable young women to the UK through the spousal route. Often these women have a poor grasp of English and no external support network in this country. This creates the perfect conditions for abuse and exploitation, and effectively enables the introduction and furtherance of a family culture which is totally alien to Britain. In 2016, Dame Louise Casey published the Casey Review, a review into opportunity and integration, particularly in isolated and deprived communities. In her report, she discusses immigration and the impact it has on integration. This is a highly sensitive issue. Dame Louise Casey's language is nuanced and carefully chosen, and I cannot do better than repeat it here. She says, rates of integration in some communities may have been undermined by high levels of transnational marriage, with subsequent generations being joined by a foreign-born partner, creating a first generation in every generation phenomenon, in which each new generation grows up with a foreign-born parent. This seems particularly prevalent in South Asian communities. We were told on one visit to a northern town that all except one of the Asian counsellors had married a wife from Pakistan. And in a cohort study at the Bradford Royal Infirmary, 80% of babies of Pakistani ethnicity in the area had at least one parent born outside the UK. As Casey herself says in the report, I know for some the content of this review will be hard to read, and I have wrestled with what to put in and what to leave out, particularly because I know that putting some communities under the spotlight, particularly communities in which there are high concentrations of Muslims of Pakistani and Bangladeshi heritage, will add to the pressure they already feel. However, I am convinced that it is only by fully acknowledging what is happening that we can set about resolving these problems and eventually relieve this pressure. Dame Louise Casey was brave to acknowledge and discuss these problems so honestly in the hope of solving them, and we must find that same courage. We believe that the cap on spousal visas, both overall and from individual countries, that we suggest here in this amendment would help with this challenge, and we sincerely hope that the government will consider it. Turning now to new clause 39, I think we have already today covered various elements of the rules here, whereby we are hoping to ensure that anyone who comes to this country is and remains a net fiscal contributor, with a view to ensuring that across their lifetimes, people who come to Britain contribute more to the public purse than they cost. We have, again, already spoken about rules and conditions relating to foreign criminals, the cost of social protection, and the groups to which we believe that should be limited, and the need for these sorts of visas to come with quite serious caps quite serious flaws, on salaries. Turning finally in this group to new clause 40, the numerical visa cap. As I have mentioned in the context of this committee before, every election-winning manifesto since 1974 has promised to reduce immigration. Time and time again, governments of both parties have failed to deliver on that promise. Perhaps even more scandalously, those same governments have often attempted to shift the blame for that failure, refusing to take responsibility for overseeing an immigration system which does not align with the expressed wishes of the British people. Gladly.
Thank you for giving way. Given that she's previously worked in a special advisor role and you're lecturing us about caps, I'd like to ask how her government was successful with the caps that they set.
I thank the honourable member for his intervention. I think and I hope that it has been clear from everything that I've said that I make no defence of the activity of the last government, and I think it is incredibly important that we on this side of the House are able to, as is our duty and responsibility to the public, talk about the many things that went wrong and hopefully help the government not to make the same mistakes that we did. Happily.
Thank you for giving way again. I appreciate this collegiate working environment that we're now in. In that case, will she expand on the caps that were set by the previous government and then the results that came after?
I thank the honourable member for his intervention. I think, as I've already set out, there was never what we're talking about here, which is a formal cap set by Parliament and legislation, but there were a number of aims and promises made to the electorate over the years, and those promises were not kept. Selective, limited and tailored to our needs. This is the immigration system that the British public has voted for time and again. If we are serious about delivering this, we must take steps to ensure that future governments do not renege on their promises as previous governments have. But this is not just about delivering the immigration system that the British people have repeatedly voted for. Fundamentally, it is about public trust and accountability. Put simply, a hard numerical cap on the number of visas issued each year would force the government and Parliament to take accountability for its decisions on immigration. If we believe that the overall level of immigration is too high, then we should set the cap accordingly, ensuring that technical mistakes do not produce the kind of migration wave which we have seen over the past few years. If we believe that the overall level of immigration is too low, then we should be willing to say this publicly, to explain our reasons and to defend our record. Either way, we must be transparent. This will not rebuild public trust in our political system overnight, but it will represent a significant step in the right direction. Gladly.
I thank the lady for giving way. In a previous sitting, she was referring, I think, to the SNP member about humanitarian and safe and legal routes, and she highlighted that some of the difficulty really is that when a humanitarian event happens, it happens often without warning and anticipation, and our country and other countries will respond as quickly as possible, and one of the ways in which it responds might be to open up a safe and legal route. So in her amendment, does she make any accounting for any possible scenarios that arise, recognising it's hard to anticipate those? Is there any flexibility in the numbers that she provides for the visa category, which would support people coming in who are refugees and people in genuine need?
I thank the honourable member very much for his intervention. As you should be able to read from the wording of the clause, it doesn't say that these caps have to be set and then can't be revised. It is more than possible to come back to Parliament and change them. If such a situation arises, and he's totally right to say that a lot of these are urgent or emergencies or unforeseeable, then there's no reason, I don't think, why that case shouldn't be made to the British public and that cap be changed. But what we're talking about here is the need for that case to be made to the British public and for that transparency. Some honourable members on the benches opposite have mentioned my time in the Home Office. I was a special advisor in the Home Office. I worked primarily on national security, and I didn't work on legal migration. But one thing that was very, very clear to me from what I could see from the problems that all of my colleagues were facing is that most government departments, and the minister sitting opposite may be experiencing this now, are geared for higher levels of migration. So it is helpful for the Department for Health and Social Care, for example, to have very high volumes of health and social care visas issued. It's helpful for the Treasury, who is looking to issue gilts based on our overall GDP, to have as many people here as possible. The purpose of this cap would be to bring those conversations out into the open, and if those departments wished, and those ministers wish to justify to the public and to the British people why those numbers need to be higher, we think that that conversation can be had where the British people can hear it. I'm finishing, but I will happily do so.
Thank you, and it's just a clarification. So there's a mention here about the Secretary of State making regulations specifying the total maximum number of persons who may enter the United Kingdom annually. I'm assuming that the Secretary of State, within 6 months of the passing of this Act, won't on an annual basis have to specify what the cap would be for each visa category. What you're saying here is, what I assume the Honourable Lady is saying here is that there may be a statement that's made which provides for the annual cap per visa category over, say, 4 or 5 years, that the Secretary of State would not have to come back each year. Am I right in thinking that, or am I wrong? Could you clarify?
Thank you. I thank the Honourable Member for his intervention. And he asked a good question in that I am not sure that it is explicitly decided on the face of the bill. I think that that could be something that the Home Office could decide subsequently, whether they wish to set up future years or just this one. But I think in my initial response to him, the point that I was trying to clarify was that cap can, of course, be changed. Once it's set, it doesn't need to be set in stone forever. But it's important that it exists and that the conversation about what it should be is had in front of the British public.
Thank you, Mr. Chair. It was very interesting to hear the Honourable Lady setting out her argument very, very articulately, and it was really good to hear her say that she recognises that the last government made a lot of mistakes on immigration and that the evidence shows that. Sadly, although it's good to have the recognition, it doesn't seem as if very much has been learned from the experience of the Conservatives in office. Just turning to each of the sort of clauses that they've set out. First of all, on the spousal visas, quite a lot of what's in this proposal actually exists already. There are already salary thresholds and things like that. Actually, unlike me to praise the previous Conservative government on immigration, but actually across previous administrations, both Labour and Conservative, there have been very good work on sham marriages and forced marriages and issues like that. But what is new in this clause, which is a very strange and horrible power to give ministers, is the ability to either ban nationalities from that British people can marry, or set thresholds on it. Now, I have huge respect for my friends, my honourable friends and ministers in the Home Office, but I don't think they should be able to choose what nationalities I'm allowed to marry. And if we think about that in reality, we in the 20th century got rid of anti-miscegenation laws. We don't want to see them coming back into the back door through clauses like this. And most of all, what's very strange is this arbitrary 7% number. As if, like, if I were to marry, say, an Australian or American, I better hope that I'm not in the 8% of the country that's done it. That seems to be a very strange way for us to ask British citizens to live their lives and fall in love with people. They also made the point about the legislation needs to look backwards and make sure that migrants are net fiscal contributors over their lifetime. I would say again, that's not a realistic thing to ask government to can do. We'll only all know if we've been net fiscal contributors when we die, and so we can't really ask people to make those projections. Finally, the point about the numerical visa cap. Again, this is a gimmick that isn't addressing the actual structural problems in the immigration system. First of all, it treats all migrants the same as one big monolithic whole, and we know that the impact of migrants in communities is different, whether they're a spouse or a student or a doctor or a lorry driver or a refugee. If you're going to have this kind of cap, how do you prioritise? Will it go throughout the whole of the year? How will business plan if they want to recruit from overseas? As my honourable friend from Bournemouth said, what if emergencies mean there are more people coming in? We already found in the last Conservative government that they set a cap for Tier 2 visas, and then, of course, they ended up hitting it and just exempting NHS doctors and nurses from it anyway. Isn't it inevitable that history will just condemn to repeat itself if we do it here? And then, of course, over the whole, We've talked a lot about public trust in the immigration system and how that's been so deeply sapped by failures on immigration policy. The Conservatives had a net migration target of 100,000 a year, which they consistently failed to meet and had to revise. This proposal is just advocating repeating that exact same mistake, but hoping for a different outcome, which seems bonkers to me.
Yeah.
Thank you very much, Dr. Morrison. A number of the issues that have been debated in relation to these clauses have already been debated in relation to other clauses. And so I will keep my remarks fairly brief in relation to some of the additional issues. New Clause 35 proposes a cap on the number of entrants as a partner and amends the immigration requirements for a partner of a person present and settled in the United Kingdom. The provisions for family members to come to or to stay in the United Kingdom are set out in the immigration rules, and I'll gently make the point again that this isn't the correct legislation for a debate about requirements for partners. The government's position is clear that we support the right of people to family life and value the contribution that migrants make to our society, but this must be balanced with a properly controlled and managed immigration system. And it has been the case that for too long net migration has been too high, and also that we have seen significant abuse on the routes, which should have been designed with some tighter safeguards under the previous administrations, the consequences of which we are catching up with now and seeking to deal with as we seek to bring order to our system and bring back public confidence as well in our immigration system. So the government has been clear that net migration must come down, and our immigration system welcomes people from across the globe to come to the UK. They may join family here, and it is and we do think it's right to continue to enable family migration. For the points that a number of my honourable friends have raised, British citizens and those settled in the UK are free to enter into a genuine relationship with whomsoever they choose. And if it is if they wish to establish their family life in the UK, it's appropriate they do so on the basis that they can support themselves financially without recourse to public funds and can participate sufficiently in everyday life that supports their integration into British society. And to ensure financial independence, applicants on the family route must also show that they meet either the minimum income requirement or adequate maintenance. The minimum income requirement is currently set at £29,000, and to ensure that we have a solid evidence base, and indeed we've been talking about evidence bases in the context of these debates, to ensure we have a solid evidence base for any future change. On the 10th of September, the Home Secretary commissioned the Migration Advisory Committee to review the financial requirements in the family immigration rules. And new Clause 39 places specific conditions on those applying for permission to enter or to stay or to settle in the UK, and removes the Secretary of State's discretion to grant leave outside of the immigration rules. Now, the government recognises and values the contributions, and I've said, that legal migration makes to our country. And indeed, the immigration system controls access to benefits already. The no recourse to public funds policy is long-standing, as I've already referenced in debates today. And most migrants only become eligible to access public funds at the point at which they gain settlement, namely ILR. And this approach reflects the need to maintain the confidence of the general public that immigration brings benefits to our country rather than costs to the public purse. Now, in addition to these controls, subject to the visa route being accessed, individual migrants are required to meet conditions attached to that route. For example, for the skilled worker route, that includes a minimum income requirement. And the immigration system also needs to account for people in a range of circumstances and not adopt a blanket approach that would capture, for example, those visiting the UK as tourists. We've referenced also and extensively in the debate foreign nationals who commit offences. And so I do just want to turn briefly to new clause 40, which I think can make the broad point again that which seeks an annual maximum number of persons who may enter the UK across all visa groups. So the government is clear that net migration must come down, and I think we've seen this issue of numbers, arbitrary numbers rehearsed, not to great effect over the last 14 years. There is work underway, and it's important work underway to restore order to our immigration system. And we are, as I've mentioned, setting out that approach in the forthcoming white paper. But I would note that the government has retained the duty to introduce a non-binding cap on arrivals on safe and legal routes, though I recognise the new clause under discussion is much broader than that. And the cap that we have on safe and legal routes helps to manage the pressure, for example, on local authorities, and make sure that as people come here, it is in line with our capacity to receive them.
Thanks. We think it's right that there should be limits on the number of people who can arrive here as a spouse or partner, a requirement on those bringing people to be able to support themselves, and a cap on the number of people entering the country. We wish to move to a division.
New clause 35 proposed as on the amendment paper. The question is that the clause be read a second time. As many as are of that opinion say aye.
Aye.
Aye. To the contrary, no. No. Division. Division ignored.
Jade Boswell. No. Dame Angela Eagle.
No.
Will Forster.
No.
Becky Gittins.
No.
Tom Hayes.
No.
Katie Lamb.
Aye.
Martin McCluskey.
No.
Seema Malhotra.
No.
Margaret Mullane.
No.
Chris Murray.
No.
Susan Murray.
No.
Kenneth Stevenson.
No.
Mike Tapp.
No.
Matt Vickers.
Aye.
Joe White.
No.
Pete Wishart.
No.
Ayes were 2, the noes were 14. So the noes have it, the noes have it. Unlock. We now come to new clause 36. I call Matt Vickers.
Thank you, Dr. Morrison. Now I rise to speak in support of Clause 36. Clause 36 is vitally important in giving immigration enforcement the powers they need to smash the gangs and tackle any criminality surrounding those who arrive here illegally. This clause would give immigration enforcement access to asylum accommodation centres. Currently, there are limitations around the detention of those arriving illegally on small boats. These limitations arise due to a lack of statutory power, as well as a lack of state capacity to detain those arriving illegally. In government, the Conservative administration set up accommodation centres. These provided a plausible alternative to using hotels. Since these accommodation centres were not used to make immigration decisions, this meant that in practice, immigration enforcement officers did not find it possible to enter such centres for the purposes of examining, arresting and detaining persons residing therein for the purposes of refusal and removal. Tony Smith, the former Director General of the UK Border Force, has powerfully argued that immigration enforcement teams must have clear authority to enter all places where asylum seekers are residing, to examine, interview, arrest or detain them as appropriate. We on this side of the House agree wholeheartedly, for these would be proportionate powers for the state to use to enforce the law. At current, centres housing thousands of small boat arrivals are not detention hubs. Instead, they are in effect halfway houses between the point of processing and where decisions can be made. Consequently, there is a substantial asylum backlog which has created bottlenecks in the system. This is simply inadequate for everyone involved. It cannot continue and it must stop. This clause, hence, tries to change and end this current predicament and failure within the system. Enforcement cannot be allowed to be bereft of action, unable to chase absconders who vanish into ether without trace. We need to empower officers into these sites to interview, arrest and detain where appropriate. This would allow faster decisions, faster refusals and quicker removals. This means a more efficient system, saving hard-working taxpayers money in the process. Not only that, but Clause 36 will help decimate the business model of the people smuggling trade. Just in the last 2 years, traffickers have accumulated hundreds of thousands, if not millions of pounds in profit. We all know the consequences, the tragic consequences of people who have made this life-threatening journey. We have to, at all costs, undermine the business model of the people smugglers. That is why that is the truly compassionate thing to do. That is why I'm proud to support Clause 36, because it eliminates gaps within our asylum enforcement system. It ends centres being off limits and hence makes it much more difficult for people to get lost within the system. So we have to act and act now. Clause 36, hence, appears to be common sense, allowing our enforcement agencies the access the average person probably would assume they already had. I'd therefore be interested in the Minister's views about whether an amendment or a power like this would be of operational benefit to immigration enforcement, and if not, why not?
Access to accommodation centres, immigration enforcement.
The question is that new Clause 36 be read a second time. Pete Wishart.
Thanks against Dr Morrison. I really don't want to detain this committee for all that long with this amendment, but this is just another abhorrent amendment from the warped imagination of the Conservatives. And I don't know where they come up with things like this, because it has to be very creative to be so cruel as to propose something quite like this. This amendment would allow immigration enforcement officers to visit accommodation centres at any time without prior notice. Asylum seekers and other residents of these centres are often fleeing persecution, war and violence, and they have suffered severe trauma. The constant threat of unannounced visits from immigration enforcement will create an atmosphere of fear, making it even more difficult for individuals to feel safe. Allowing immigration enforcement to visit any resident at any time is a clear violation of privacy. It undermines their dignity and well-being and could lead to harassment or increased surveillance, further marginalising already vulnerable populations. Vulnerable individuals should not be made to feel constantly watched or threatened by authorities, especially when they are seeking safety and stability. And the presence of immigration enforcement officers may discourage asylum seekers and migrants from seeking support or reporting issues of abuse, exploitation or trafficking. All of this could do is undermine the very support structures designed to help individuals rebuild their lives in the UK. This amendment lacks any clear safeguards or accountability mechanisms for how immigration enforcement would operate, and I urge the committee to reject it, and I hope they reject the rest of their amendments too.
Thank you, Dr Morrison. This new Clause 36 would give access to asylum accommodation centres to our immigration enforcement officers. Members of the public may in fact be surprised to learn that this power does not already exist. It seems to me common sense that where a person has come here illegally and is being housed by the state, that immigration enforcement, an arm of that state, should be able to enter that accommodation to carry out their work. As my honourable friend, the member for Stockton West, has rightly set out, these accommodation centres exist because the volume of those coming here illegally is such that it is not possible to hold everyone in immigration detention. There are therefore substantial numbers of people on immigration bail, and a reasonable number of those are held in accommodation centres. Immigration decisions are made elsewhere, but this is the criterion set out in current legislation. In our view, this is a quirk of the current system and not how one would design it if starting from a blank page. These sorts of accommodation centres did not exist in the way that they do now when our rules were written, and we think that this corrects that quirk. So I echo the question of my honourable friend, the member for Stockton West. Does the Minister think that this would be of operational benefit to immigration enforcement officers? If so, will she include it? And if not, why does she not think so?
Thank you very much, Dr. Morrison. New Clause 36 seeks to provide a right of access upon request for Home Office teams working within immigration enforcement to asylum accommodation centres in order to visit these centres and residents at any time. Immigration officers have powers to be granted a warrant to enter residential premises to search for and arrest someone for the purpose of detention and removal from the UK, and to search for relevant documents while there. In practice, immigration officers will often seek and obtain access to premises with the consent of the owner or occupier of those premises. I note that the new clauses make reference to accommodation centres. I would welcome clarity from the party opposite as to whether the intention is to specifically attach this power to accommodation centres. My reason for asking is that the Home Office has not stood up any such centres in the form defined under the Nationality, Immigration and Asylum Act 2002. In other words, they don't exist. More widely, care needs to be taken to ensure the use of the proposed power is managed appropriately. The access the power provides in this new clause is very broad, and it applies to anyone working within immigration enforcement, the Directorate at the Home Office, which would include all civil servants working there, not just immigration officers who have the relevant training. If the rationale behind this clause is to remove a perceived barrier to the removal of migrants with no status in the UK, access to the premises in which an individual is residing is not such a barrier. Whilst there may be some constraints on immigration officers entering asylum accommodation sites, including hotels, these are of a practical nature linked to risk assessments, public order, disruption, safety of staff and other residents, rather than lacking a statutory power of access. They already have a statutory power of access. So overall, this amendment is unnecessary because immigration officers already have powers of entry to residential premises to administratively arrest someone liable to removal and to search premises with a warrant if we cannot obtain consent which allows for the safeguard of judicial scrutiny.
I think the public will be stunned to hear actually that immigration enforcement officers have challenges in accessing asylum accommodation centres, as outlined by Tony Smith, the former Director General. We wish to move to a division.
Before the Honourable Gentleman moves to a division, this new clause actually talks about accommodation centres which don't exist. So what does he mean by accommodation centres?
We have had a provision for accommodation centres. We have accommodation.
But they don't exist.
But as we're moving, I know there's 8,500 more in hotels now, but this was a measure that was put in place to reduce that hotel dependency, to stop us increasing the number of people in those hotels by 29%. Yeah, happy to move to a division.
Just to put on the record, and obviously then we'll vote. There's a specific meaning in law under the Nationality, Immigration and Asylum Act 2002 for the phrase accommodation centres. No government since that law was passed have actually stood up accommodation centres under that specific meaning. Therefore, the Honourable Gentleman in his new clause 36 is asking for powers to enter something that doesn't exist.
Given the Minister, I think you should perhaps ask the Conservative spokesperson, does he actually mean hotels?
Well, thank you. I thank the Honourable Gentleman, the member for Perth and Kinrossshire. I thought that perhaps, I was trying to help, that perhaps what the Honourable Gentleman was trying to do was talk about accommodation generally. If that is the case, Dr Morrison, we already have the powers we need to enter when and where we wish. This power is much broader and we wouldn't like to see it put into effect, which is why I hope, if and when the vote comes, that honourable members on both sides of the committee will vote against this new clause becoming part of the bill.
Thank you. Question to divide, yeah. New clause 36 proposed as on the amendment paper. The question is that the clause be read a second time. As many as are of that opinion say aye.
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 To the contrary, no. No. Division.
Jade Boswell.
No.
Dame Angela Eagle.
No.
Will Forster.
No.
Becky Gittins.
No.
Tom Hayes.
No.
Katie Lamb.
Aye.
Martin McCluskey.
No.
Stephen Malhotra.
No.
Margaret Mullane.
No.
Chris Murray.
No.
Susan Murray.
No.
Kenneth Stevenson.
No.
Mike Tapp.
No.
Matt Vickers.
Aye.
Joe White.
No.
Pete Wishart.
No.
Thank you. Ayes were 2, the noes were 14, so the noes have it, the noes have it. Unlocked. We now come to new clause 37. I call Matt Vickers.
Thank you, Dr. Morrison. The Immigration and Asylum Act 1999 and the Asylum Support Regulations enable asylum seekers to obtain housing and funds to support themselves while they wait to find out whether they will get asylum. Their children can attend state schools and they're also entitled to NHS care. We know that often asylum seekers crossing the channel by a small boat are given bail and provided with asylum support. Those with no UK address will be allocated asylum housing or placed in asylum hotels or accommodation centres. The National Audit Office has estimated that the cost of this to the taxpayer is around £4.7 billion in 23-24. Yeah.
Is it the intention of the Conservative Party to build these detention centres, these accommodation centres, as part of the new immigration policy of the party?
We've had lots of alternative means of accommodation to hotels. You know, hotels are through the roof at the moment, up 29% with 8,500 people more staying in them. But this, in its context, actually applies more widely than any accommodation centre or hotel. The National Audit Office has estimated that the cost of this to the taxpayer is £4.7 billion in 23-24. The National Audit Office's £4.7 billion tab for 23-24, covering beds, meals, NHS visits, all the while the backlog ballooned to 41,000.
That number has ballooned and has gone up really highly, not just in the overall aggregate, but per asylum seeker. And if you're going to try and charge people for what they've done, you've let the system get completely out of control. Maybe it was the backlog that was letting it get out of control rather than the kind of hotels they were staying in.
Well, the reality is that somebody's getting charged for it and somebody's paying for it. And at the moment, it is the great British public. So, yeah, there are ballooning costs. They're increasing numbers, as we know. Number of illegal arrivals up 28% since the election, 29% more in hotels. Less of those people arriving illegally are being removed. So, yes, the number goes up and the cost continues to go up. And somebody's got to pick up the tab. Making that repayable once they're working, say £10,000 over a decade, could claw back hundreds of thousands of pounds. That's not small change. It's classrooms built, potholes filled, nurses hired. Why is the government content to let this sinkhole drain us dry when we could balance the books with a system that asks those successful to pay back some of these onset, some of these costs? The knowledge that this support is available has been highlighted by Tony Smith in his evidence as a pull factor which encourages people to cross the channel. We share Tony Smith's view that making it clear that the costs of asylum support and accommodation will be recovered once the applicant is economically active could help to disincentivise future crossings. That's why we've tabled new clause 37. Our new clause 37 would enable the government to treat asylum support like a student loan, with asylum seekers able to pay back the cost of support when they're in paid employment. We believe that if someone's asylum appeal is granted and they're allowed to remain in this country and are able to work, that as and when they're able, they're required to pay back to the state the costs of their maintenance. State support is not a right. Yeah.
I think this may be our last sitting day. So I do want to say with hopes that it is. But I also want to say that over the last few sittings, having not known the honourable member, I've grown in admiration for him because he's had to come and defend very difficult things from the previous government. It's felt a little bit like he's been a goalkeeper in front of a goal without any gloves on, and he's had balls being hit at him from every direction. So I do have admiration for him. But this is frankly absurd. It really is bonkers. And I just want to assess, is this the honourable member's idea, or is it somebody else's idea that he's having to make the case for? Because I really, really hope it's the latter.
Well, to his electors and mine, these things come at huge cost. Huge costs. As we've set out, this money could be used by those people who pay in to the system and have done for a very long time. We've made the analogy there of student tuition fees. I think it's very relevant. I'm grateful for his well-hidden admiration of recent times, but no, I think it's the right thing to do, and I'm well on board with it. State support is not a right, and if a person is able to later contribute by paying some of that back, we believe it's right for them to do so.
Asylum support repayment scheme.
The question is that new clause 37 be read a second time. Katie Lamb.
Thank you, Dr. Morrison. We have spoken many times today and over the course of this bill committee about the fundamental principles of fairness upon which we believe our immigration system should be built. We have also spoken extensively about the generosity of the British state and how much in practice it costs to support those who, according to our rules, cannot support themselves. But this generosity, whilst admirable in what it says about our approach to our fellow man, costs the British taxpayer dearly. As my honourable friend, the member for Stockton West, sets out, this is many billions of pounds a year. It also causes additional pressure on infrastructure and public services, which isn't covered here by what we suggest. This new clause 37, the Asylum Support Repayment Scheme, we think is a totally fair way of proposing that people who come to this country are responsible for contributing for the services that they receive. That includes the accommodation that they live in. We don't see any reason why this should be viewed as a negative change, and we really hope that the government includes this in their bill.
Minister.
Thank you very much, Dr. Morrison. New clause 37 would give the Secretary of State regulation-making powers to set out arrangements for asylum seekers to receive loans towards their maintenance and accommodation. But as we've discussed at this committee during scrutiny of the bill, the cost of accommodating and supporting asylum seekers has grown significantly. The reason for this increase is due to inheriting an asylum system under exceptional strain, with tens of thousands of cases previously at a complete standstill, the PERMA backlog, which we have referred to on many occasions during our proceedings in the last few weeks, without claims being processed, and a record number of people arriving on small boats in the first half of the year. Whilst immediate action was taken to restart asylum processing, we cannot resolve this situation overnight, but it remains our commitment to reduce the cost of asylum accommodation, including ending the use of asylum hotels. The size of the existing backlog, particularly in appeals, means we're forced to use hotels in the meantime. This is not a permanent solution, but it's a necessary and temporary step to ensure the system doesn't buckle under exceptional strain. The speed at which the system can be run, the speed at which asylum claims can be processed and dealt with, is the best way of dealing with this issue of cost, in my view. And I think that I can say on all sides, we want to see the costs come down. We want to see a properly functioning immigration system that delivers fair, timely decisions and manages public funds. Hotel costs have actually dropped from over 9 million a day to under 6 million a day, and overall the department is planning to deliver £200 million of additional in-year savings in 2024-25 and £700 million of savings against 2024-2025 levels during the following financial year on asylum costs. These measures taken together would represent a saving over £4 billion across 2024-5, 2025-6 when compared to the previous trajectory of spending. The Home Office has a legal obligation to set out, as set out in the Immigration Act 1999, to support asylum seekers, including any dependents who would otherwise be destitute. Destitute is the phrase that people need to remember there. Asylum seekers can apply for accommodation, subsistence, or both accommodation and subsistence support when they're destitute. Once official refugee status has been given, the individual is able to work in the UK. Although asylum seekers generally do not have the right to work in the UK while they're waiting on a decision about their asylum claim, there are some instances in which they can apply for permission to work. They're eligible to do so if they've waited over 12 months for an initial decision on their asylum claim or a response to a further submission for asylum, and they are not considered responsible for the delay in decision making. In that context, the amendment proposed by the Honourable Member of Stockton West is an interesting one, and I'd welcome clarification on how such a loan scheme would operate alongside or instead of the current system. Also, the details of any assessment, the practical or economic benefits of such a scheme. Further scoping would be necessary in order to establish whether this is in fact a feasible option. As such, inclusion in this bill is premature. We're exploring a wide range of options to support ending the use of asylum hotels for asylum seekers and reduce the significant costs to the taxpayer. We're open to interesting ideas, but this is far too early in any kind of approach that we should put a new clause saying this in this way in the bill at this time.
Who pays is the big question. There is a huge cost here. I'd never seek to get political about the political choices made with some of the funding of recent years. I wouldn't go into the winter fuel payment and all that sort of stuff, or the increase in tuition fees. But tuition fees is actually quite an interesting comparative because we ask those who are able to contribute for the costs that are incurred in delivering them that education. We should be asking people who arrive in this country who go on, could become very successful in the future, to contribute to some of those costs. Yeah.
Okay, Gina.
Thank you, Dr. Morrison. I welcome the Minister's response. I wonder whether, please, she might commit today to a date when at least the Home Office is aiming for all migrant hotels to be closed as per her party's manifesto commitments. I also welcome what the Minister had to say about bringing down costs. She is right to say that the best way to minimise the Home Office's bill for asylum accommodation is to process applications as quickly as possible. Where asylum applications are approved, though, most of those costs transfer to the welfare system, so I would be interested to hear the Minister's response as to who in government is currently responsible for tracking and understanding what that cost is.
Well, I think, Dr. Morrison, we inherited a system that was very, very silent, where work was not really cross-departmental at all. And one example that occurs to me is the legacy system that dealing with all of the legacy applications which the previous government embarked on dealing with at first here in 2023 and then boasted about achieving, was actually only the first initial decision in the system. If one was granted, I suppose, one was felt lucky, but those who weren't granted appealed. Whilst the Home Office congratulated itself publicly under the previous government in dealing with that legacy system, actually many, many people were still in the system. So it's been an important thing that we've done since we came into government to try to begin working cross-departmentally and developing the metrics about how to deal with an end-to-end system. We're not there yet. We understand that costs can sometimes be transferred to other areas, which is why I'm working very closely with the LGA, the MHCLG and the MOJ to try to get the system end-to-end working more effectively. I can't give her a date when hotels will close, but I can say that we're doing our best, given the huge cost and the contracts that we inherited from the party opposite for providing them being so expensive. It will certainly be in the interest of saving lots of money to close them as soon as we can, and we're certainly aiming to do so.
Thank you, Dr. Morrison. Again, totally rightly and reasonably, the Minister talks about lowering costs, but I wonder if she might say a few words about fairness and on the principle that this amendment seeks to speak to, which is, should those who have lived in this accommodation, who have benefited from this provision from the state, ultimately pay it back if they can afford to?
Dr Morrison, I haven't dismissed the idea completely, and she will have noticed that. But I don't think the idea is anywhere near a situation where one could talk about how it might be practicable, and certainly not at a stage where one could consider putting it into primary legislation.
The Shadow Minister wishes to press his amendment.
Yeah, state support is not right. And if a person able to later contribute by paying some of that back, we believe it's right for them to do so. We do wish to press it to a division, please.
New clause 37 proposed. As on the amendment paper, the question is that the clause be read a second time. As many as are of that opinion say aye.
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 To the contrary, no.
No.
No. Division.
Division denied.
Jade Botterill.
No.
Dame Andrew Eagle.
No.
Will Forster.
No.
Becky Gittins.
No.
Tom Hayes.
No.
Katie Lamb.
Aye.
Martin McCluskey.
No.
Stephen Malhotra.
No.
Margaret Mullane.
No.
Chris Murray.
No.
Susan Murray.
No.
Kenneth Stevenson.
No.
Mike Tapp.
No.
Matt Vickers.
Aye.
Joe White.
No.
Pete Wishart.
No.
Thank you. The ayes were 2, the noes were 14, so the noes have it, the noes have it. Unlocked. We now come to new clause 38. I call Matt Vickers.
Thank you, Dr Morrison. Our new clause 38 would require the government to make changes to arrangements for leave outside the immigration rules. This new clause would require the Secretary of State, within 3 months of the passing of this Act, to consult on reforms to arrangements for leave outside the immigration rules. This consultation must consider how best to ensure that leave outside the rules is granted only in the most exceptional circumstances, in which a reasonable person would consider it unacceptable to refuse entry to the United Kingdom. Within 18 months of the passing of this Act, the Secretary of State must, by regulations, make changes to the immigration rules to implement the required reforms to leave outside the rules. We've tabled this amendment because we're concerned about the government's response to the recent decision in the upper tribunal to allow a family from Gaza to obtain permission to come to this country using the Ukraine family scheme. The appellants were Palestinians who were at the time of the decision under challenge residing in Al-Mawazi, humanitarian zone of Gaza. The first and second appellants were husband and wife and had lived in Gaza since 1994. They were the parents of the remaining 4 appellants who at the time of the decision were 18, 17, 8 and 7 years of age. The sponsor for the application was the first appellant's brother, who had moved to the United Kingdom in 2007 and is now a British citizen. The first-tier tribunal declined the application and the decision was appealed. The main issues to be decided by the first-tier tribunal were whether there was family life under Article 8.1 between the appellants and the sponsor in the UK, whether the respondent's decision interfered with any family life and or any private life enjoyed by the sponsor, and whether any such interference was disproportionate. The upper tribunal did not agree with the Home Office's argument that the first-tier tribunal judge had erred in finding that there was family life between the appellants and sponsor. It found that there was family life and that the Home Office decision not to allow the family leave outside the rules was a disproportionate interference with the family life of the appellants and the sponsor. When the leader of the opposition challenged the Prime Minister about this particular case at PMQs, he responded that he did not agree with the decision of the upper tribunal and the government was looking at the legal loophole that needed to be closed in this particular case. Our amendment makes a suggestion about what that legal loophole might be, but I think it's extremely important that the Minister is able to answer the following questions. Did the Home Office decide not to appeal the upper tribunal decision? If so, why? What is the legal loophole that the Prime Minister referred to the Home Secretary closing? Can the Minister be extremely precise about this, please? And can the Minister explain when the House will be updated on this issue? And if there is a legal loophole to close, why is that not being done through this bill?
Leave outside the rules. Consultation.
The question is that new clause 38 be read a second time. Minister.
Thank you very much, Dr. Morrison. I do find this a very interesting debate and an important one in a number of respects. And the members' new clause 38 does place a requirement for a consultation on the government's approach to the exercise of discretion to grant leave outside the rules, on what any reasonable person would consider to be the most exceptional circumstances to warrant a grant of leave outside the rules, with a requirement for a change to the rules to to regulate on the basis of what discretion may have been exercised. Now, the rules set out the main purposes for which a person may be able to may enter or stay in the UK, and the requirements to be met for them to be granted permission to do so. The rules already consider where there are exceptional circumstances, and the rules are intended to apply and to be applied in most circumstances to ensure transparency and fairness between individuals. The existing policy approach recognises there are some circumstances which these rules simply cannot cater for. It is in these most exceptional circumstances that consideration is given to leave outside the rules under the Immigration Act of 1971. Now, a period of leave outside the rules granted would usually be for short one-off periods of entry clearance or permission to stay, suitable to accommodate or overcome the exceptional circumstance or compassionate, compelling grounds raised in the individual case. And a person may request an exercise of discretion, and factors considered including those may be related, for example, to emergency or unexpected events, a crisis, a disaster, or an accident that could not have been anticipated, or personal tragedy. And it is the case that the government will continue to consider where and when there is a need to exercise discretion outside of the rules, which by its very nature is something that's only considered in the most exceptional of circumstances. Now, he raised a specific case which is probably not appropriate for me to go into beyond what has been said in the House. He asked some very specific questions. I'm happy to come back to him with what I can in writing on that. But I think it's important to say that this is not the correct legislation for the debate about the requirements for discretion to grant leave outside of the immigration rules, nor the correct place to define on what parts of immigration policy this government should consult.
Just in the context of that specific case and this loophole and why she thinks it's not relevant in this space, what does she identify that loophole as being, and why does she not feel that that broader issue is relevant in consideration of this bill?
No, I think the Shadow Minister will understand what this bill is about, and he will understand how it is about making sure that we can stop and the criminal gangs have new powers to do so, and he understands that extremely well. In relation to other clauses that he has brought forward, I've given the same response in relation to aspects of immigration rules, which this is not the correct place. This is not the correct legislation to define on parts of immigration policy, or try and determine on what this government should consult. But as I have said to him, the government does continue to consider where and when there is a need to exercise discretion outside of the rules, which by its very nature is, as I've said, something that's only considered in the very exceptional of circumstances. And I've also shared what some of those factors may be in relation to unexpected events, or in relation to a crisis, or an accident that could not have been anticipated, or a personal tragedy, matters in which I'm sure that he will understand, considering he has had his own time in serving in office as well.
I think, you know what, it's a very valuable and important debate. It's an issue that was you know, heartfelt by many people. The decision in that case flew in the face of the values demonstrated by the Ukraine scheme. It could undermine commitments to future such schemes, so is with great consequence, really.
Katie Lamb.
Thank you, Dr. Morrison. I'm a little confused, I suppose, by the Minister feeling that several of our amendments should not be debated with this bill. My understanding, and I fully concede that she is more experienced than I am, is that any amendment considered in scope can be laid, debated and voted on, and by virtue of the fact that these amendments were considered in scope. So I'm interested as to why she thinks that it's not appropriate for us to discuss them today.
I thank the Honourable Member, the Shadow Minister, for her role. What I've said is that I'm not disputing that there can be a debate. What I'm saying is that this legislation has got a clear purpose and is a defined purpose, and to seek to extend this legislation to be more than what it's designed to be would not be appropriate when there are other means and mechanisms through which immigration rules are debated in this House.
Thank you, Dr. Morrison, and I thank the Minister for her response. Might she then, just for clarity, sort of lay out what the government do consider the purpose of this bill to be, and therefore, I suppose, by implication, what it isn't?
I thank the Shadow Minister for asking what this bill is about. We're just at the end of scrutiny of this bill, and I'm sure that she is aware of what this bill is about, which is to look to how we increase powers, particularly to be able to tackle better the criminal gangs that are undermining our border security and putting lives at risk, and making sure that we have the new bodies, the Border Security Command, on a statutory footing, and many of the other debates that we've had in this House.
Often with these amendments, like to bring things out into the light. And one thing I haven't quite heard of is, what is the government doing in light of the issues around the Ukraine scheme, in regard particularly to that case and what's happened, to prevent this happening? We've got this big borders bill coming through. The answer to the world's problems, hopefully, on borders, it's going to improve the situation. But in terms of that Ukraine scheme and its misapplication, is the government doing anything in that space to ensure that it's not going to happen again and does not have the potential to happen again?
You're right, and the Prime Minister laid out the view that it was the wrong decision, and you're right on that. And also, we do need to find a way to tighten up how Parliament has also understands the rules and how they're interpreted. But like I say, this is not a matter for this legislation, which I think we're at the very end of debate around, and now being asked what this bill is for. I don't suppose, I'm sure that the Shadow Ministers don't want to go all the way through the debate again on line by line, but suffice to say that the matters in which the Shadow Ministers are seeking to extend this legislation into broader aspects of immigration are not, in our view, appropriate for this bill, and there are other mechanisms and debates for where we seek to debate and change immigration rules.
Thank you, Dr. Morrison. I thank the Minister for responding to me earlier. Our view on this side of the House is that the various ways by which people come here illegally and stay is fundamentally important to smashing the gangs, and leave outside the rules and the way in which it may be abused is a big part of that. So it seems to us, very much part of the fundamental point that we're discussing, and I wonder if the Minister could comment on that.
She is, thank you, Dr. Morrison, she is absolutely right. And in fact, I have raised a number of times during the course of the debate that we have about the ways in which we see abuse in many different ways on our routes. And indeed, the way the routes have been designed that have left them open to more abuse, and that we are now reaping the results of that in terms of some of the measures and the tightening up that we are doing. But she will also be aware that we have raised this as a matter that is important in bringing under some greater control as part of an immigration system that is more fit for the future, an immigration system that is more controlled, is more managed, and is fairer. And those aspects for what we believe can be done and should be done for a future immigration system will be what will be the subject of the immigration white paper, and I look forward to debating that with her.
May I move your amendment?
Yes, we wish to divide on the amendment.
New clause 38 proposed as on the amendment paper. The question is, the clause be read a second time. As many as are of that opinion say aye.
Aye.
To the contrary, no.
No.
No. Division.
Division in time.
Jade Botterill.
No.
Dame Angela Eagle.
No.
Becky Gittins.
No.
Tom Hayes.
No.
Katie Lamb.
Aye.
Martin McCluskey.
No.
Stephen Malhotra.
No.
Margaret Mullane.
No.
Chris Murray.
No.
Susan Murray.
No.
Kenneth Stevenson.
No.
Mike Tapp.
No.
Matt Vickers.
Aye.
Pete Wishart.
No. The ayes were 2, the noes were 12, so the noes have it, the noes have it. Unlock. We now come to new clause 39, which was debated with new clause 35. Matt Vickers to move formally.
Thank you. Oh. Yep, moving forward. Yep. Sorry.
The question,
Restrictions on visas and grants of indefinite leave to remain.
the question is that new clause 39 be read a second time. As many as are that opinion say aye.
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 Contrary, no.
No.
Division.
Jade Botterill.
No.
Dame Angela Eagle.
No.
Becky Gittins.
No.
Tom Hayes.
No.
Katie Lamb.
Aye.
Martin McCluskey.
No.
Stephen Malhotra.
No.
Margaret Mullane.
No.
Chris Murray.
No.
Susan Murray.
No.
Kenneth Stevenson.
No.
Mike Tapp.
No.
Matt Vickers.
Aye.
Pete Wishart.
No. The ayes are 2, the noes are 12, so the noes have it, the noes have it. Unlocked. We now come to new clause 40, which was debated with new clause 35. Matt Vickers to move formally.
To move.
Cap on number of entrants.
The question is that new clause 40 be read a second time. As many as are of that opinion say aye.
Aye.
To the contrary, no.
No.
Division.
Jade Botterill.
No.
Dame Angela Eagle.
No.
Becky Gittins.
No.
Tom Hayes.
No.
Katie Lamb.
Aye.
Martin McCluskey.
No.
Stephen Malhotra.
No.
Margaret Mullane.
No.
Chris Murray.
No.
Susan Murray.
No.
Kenneth Stevenson.
No.
Mike Tapp.
No.
Matt Vickers.
Aye.
Pete Wishart.
The ayes are 2, the noes are 12, so the noes have it, the noes have it. Unlocked. We now come to new clause 41. I call Matt Vickers.
Thank you, Dr. Morrison. Our new clause 41 would require the revocation of asylum or refugee status or leave to remain in relation to an applicant who returns to their country of origin, either subsequently or while their application is being processed. It would also apply to people who make an immigration human rights claim. If an individual has made a human rights claim that being made to return to their country of origin would violate their human rights and put them in danger, then if they choose to voluntarily return to their home country, it would seem that something doesn't add up. Fundamentally, no reasonable person would consider returning to their home country to be compatible with an individual's claim for asylum in such circumstances. If a person needs to remain in this country because they have a legitimate fear of persecution in their country of origin, a return to that country of origin fundamentally undercuts that claim. We've tabled... I will.
This amendment very closely, and of course conditions change within countries where people leave, and like the asylum status and human rights records change accordingly too. Is he trying to say that there is no reason whatsoever that an asylum seeker may go back to the country of origin and get back to the UK? What about family emergencies? Surely the Conservatives are not so callous as to suggest that people couldn't go back to the country of origin for a family funeral, for example.
So people arrive in this country out of fear of persecution, do you know what, some people come from the most awful extreme circumstances around. That is the bar that we put to asylum. We allow people to come here to claim asylum out of fear for their welfare, and if they're happy to pack their bags and pop back for a break, then that's on them. I believe that, and I think the public would believe, that if you come here claiming fear of persecution in your country of origin, then you should not be coming back and decide it's not an opt-in, opt-out, it's not a holiday. You're coming here out of fear of persecution in that country, and you shouldn't be going back. Fundamentally, no reasonable person will consider returning to their home country to be compatible with an individual's claim for asylum. If a person needs to remain in this country because they have a legitimate fear of persecution in their country of origin, a return to that country of origin fundamentally undercuts that claim. We've tabled new clause 41 as we think that this is a loophole that people can and do exploit. New clause 41 upholds British fairness, a value that welcomes those in need but rejects exploitation. As members know from across this House, the United Kingdom has supported over 20,000 Afghans since 2021 through the Afghan relocations policy, over 200,000 Ukrainians since 2022 via visa schemes, alongside our Hong Kong friends with BNO visas, backed further by $4.7 billion in asylum costs in 23-24. These commitments reflect our readiness to help genuine cases, those fleeing real danger with ties to Britain. The value of fairness demands a fair system that isn't abused. Yeah.
Imagine a scenario where somebody from Afghanistan, not a different country rather, from Hong Kong, goes back because their mother or their father dies, and they go in order to attend a funeral. What would happen to that person then?
So we're talking about all sorts of circumstances. I'm sure every one of these things will be pushed to the max with lots of discussions and lots of debates. The idea here is the principle that if you cannot be in that country because it would seek to your harm, it would be to your detriment, it would damage your well-being, then you shouldn't be going back. If it is such a security threat that you need to come to the UK for asylum, I think that's...
So just to clarify on that point, if a lady goes back to Hong Kong and is willing to entertain the risk in so going in order to grieve with her family briefly and to bury her mother or her father, she would lose her right to safe haven in the United Kingdom. Is that right?
People who arrive here claiming asylum arrive because they've come from some of the most terrible, awful circumstances. Their life is threatened. They're at real risk. If you are at that risk, I would say the balance of probabilities is that you would not be going back. If you fear persecution in such a way as many of the people who get asylum in this country do, then you would not be returning for that reason.
Away with this, because this is just crudely personified. I mean, would the Honourable Gentleman make every effort and take every risk to return to a country of origin if it was his mother or father?
And in the current system, so let's just, I'm hearing you, but in the current system, we allow people to pop back on holiday. Is that acceptable? No, I'm saying in those circumstances, We've heard the one extreme. At the other extreme, we've got people claiming asylum at huge cost. Not costs to well-heeled people, particularly costs to the British taxpayer. Some of them struggling to get by, contributing to this country and to this system that pays out for various other things. We want to be generous. We want to support the people who need that help. It's the right thing to do. And as we know, as we've just outlined, we have done that. But we cannot allow that generosity to be abused. We cannot allow people to pop off on holiday back to wherever they came from and come back. That's the principle that's at stake here. People out there feel it is very unfair that people pop back and use asylum here as something that's, hotel-like. That's the other extreme. That is the abuse that we're seeing, and that's what this amendment aims to end.
Would he recognise that the Hong Konger population would be very disheartened to hear what he's saying there? And does he think that it's actually right for him to stick to what he's saying, that it's not better to actually show some sympathy to that particular population who are here?
I show lots of sympathy to these people. I think it's right that we've put all these schemes in place. I think it's right that we're supporting these people in the way we are. I also think a little bit about what the British people would think about what I'm saying and about what's being said and about the abuse that they're seeing of these schemes that allow people to pop back to other countries for various reasons. You've given one extreme, I've given the other. I think that's a principle that the British public would be on board with. The value of fairness demands a system that isn't abused. When claimants return to their origin countries after securing status, they undermine that support. New Clause 41 ensures this. Voluntary return means revocation, protecting a framework meant for the truly persecuted, not those gaming it. We should be ensuring that those who genuinely need refuge and support from the United Kingdom are the first in line, not for those individuals who may want to misuse our generosity, when this simple amendment can help ensure the system is fair. I'd be interested in the Minister's views on whether it's reasonable for someone who's made a successful human rights claim to stay in this country and to return to their country of origin at will and without consequence.
Asylum or refugee claims?
The question is that new Clause 41 be read a second time. Katie Lamb.
Thank you, Dr. Morrison. Throughout our long history, Britain has been an unusually compassionate place. From time to time, people have come to this country in order to seek sanctuary from tyranny and authoritarianism elsewhere in the world. My own county of Kent became home to many of the Huguenots who fled religious persecution in France in the 16th century. Indeed, Canterbury Cathedral still hosts a French language service every Sunday in honour of those who came to this country in search of tolerance and religious freedom. My own grandmother came to Britain in 1937 at the age of 13 as a refugee from Germany. Her grandfather was a state senator and a fierce critic of the Nazis. When Hitler came to power, the whole family was stripped of their citizenships and several were arrested. After years imprisoned and various daring prison escapes, the family first made it over the border to Czechoslovakia. There they set up a resistance radio station broadcasting back into Germany. One night that was raided by the SS and one of the operators was shot dead. They then fled to England and to freedom. We should be proud of our history. There are so many Brits like me who would not be here, who would never have been born without the past generosity of this great country. But as I said earlier, we must also be realistic about the very many ways in which our system can be exploited by the cynical and the sinister. There are, of course, people who come to these shores legitimately seeking asylum. But we must also be honest about the fact that not everyone who comes to this country and applies for asylum has a legitimate case for doing so. We can see that evidenced in the fact that not all claims, of course, are approved. Too often asylum is used as an immigration route for those who would otherwise not be able to come here. Our compassion is therefore exploited by those who are in no real danger at all. A sad truth which is made clear by the fact that many would-be asylum seekers regularly return home without issue. The bar to claiming asylum should rightly be high. People should be in serious danger in their home country to be able to qualify. The members of the government benches opposite are right to say that this amendment might cause difficult and, in some instances, heart-rending situations, but that in and of itself does not make it the wrong thing to do. Last December, as I mentioned earlier when discussing our human rights legislation, a Turkish heroin dealer was allowed to stay in the UK after first seeking asylum here in 1988. Despite claiming that he would be persecuted in his home country, the man returned to Turkey at least 8 times since arriving in Britain. On one of these trips, he even got married to a woman with whom he had been having an affair, despite already being married with children in the UK. Nevertheless, he escaped deportation as it was ruled that deporting him would interfere with his right to a family life, as I mentioned earlier. These scenarios are clearly wrong and continue to contribute to this persistent feeling that so many ordinary British people have that our asylum system is broken and unfair.
Thank you very much, Dr. Morrison. New clause 41 would require the revocation of protection status or leave or discontinuation of asylum claims where an applicant returns to their country of origin. The government is in absolute agreement on the principle behind this amendment, while we're committed to providing protection to those who genuinely need it for as long as it's needed, in accordance with our obligations under the Refugee Convention and the European Convention on Human Rights. Such protection status must only be granted when it is required. As such, I want to reassure members opposite that under our existing policy, where an individual returns to their country of origin, we consider whether they have re-availed themselves of the protection of that country. Where this is the case, we seek to revoke their protection status under the appropriate provisions set out in the immigration rules. We're also clear that asylum claims may be discontinued and withdrawn where the applicant fails to comply with the asylum process, which includes leaving the UK before a decision is made on their claim. I hope the honourable members opposite are assured, therefore, that the immigration rules enable protection status to be revoked already and applications to be discontinued where an applicant has returned to their country of origin, and as such, new clause 41 is not required.
Matt Vickers.
No, I have to move to a division.
New clause 41 proposed as on the amendment paper. The question is that the clause be read a second time. As many as are of that opinion say aye.
Aye.
To the contrary, no. No. Division.
Jade Botterill.
No.
Say Mandra Eagle.
No.
Becky Gittins.
No.
Tom Hayes.
No.
Katie Lamb.
Aye.
Martin McCluskey.
No.
Stephen Malhotra.
No.
Margaret Mullane.
No.
Chris Murray.
No.
Susan Murray.
No.
Kenneth Stevenson.
No.
Mike Tapp.
No.
Matt Vickers.
Aye.
Pete Wishart.
No.
The ayes are 2, the noes are 12, so the noes have it, the noes have it. Unlock. We now come to new clause 42, which was debated with new clause 34. That figures to move formally.
Move formally.
Removals from the United Kingdom, visa penalties for uncooperative countries.
The question is that new clause 42 be read a second time. As many as are of that opinion say aye.
Aye.
Contrary, no.
No.
Division.
Jade Botterill.
No.
Say Mandra Eagle.
No.
Becky Gittins.
No.
Tom Hayes.
No.
Katie Lamb.
Aye.
Martin McCluskey.
No.
Stephen Malhotra.
No.
Margaret Mullane.
No.
Chris Murray.
No.
Susan Murray.
No.
Kenneth Stevenson.
No.
Mike Tapp.
No.
Matt Vickers.
Aye.
Pete Wishart.
No.
The ayes are 2, the noes are 12, so the noes have it, the noes have it. Unlock. We now come to new clause 43, which was debated with new clause 26. Pete Wishart to move formally. You're withdrawing the amendment. Amendment by leave withdrawn. We now come to new clause 44 in the name of Sir Edward Lee. Does any member of the committee wish to move this new clause? Katie Lamb.
Thank you, Dr. Morrison. This is a probing amendment that was laid by the Father of the House to seek to tease out what he feels are important issues to discuss in the context of this bill. I would like to make very clear that the opposition front bench is neither supporting nor opposing this amendment. The honourable member for, my honourable friend, the member for South Northamptonshire, ideally would have spoken to this clause on this side of the House, but she has Parliament-related business elsewhere today, and so I am standing in. The background to this is that various international treaties impose or have been interpreted as imposing an obligation on states not to send people back to a country where they would face harm. This is known as non-refoulement. However, not all non-refoulement obligations are the same, and there are important differences. This amendment seeks to tease out the differences between the ECHR on the one hand and the Refugee Convention and Torture Convention on the other hand. One key difference regards whether there are any exceptions to the principle of non-refoulement, which is to say, are there any circumstances where someone can be sent back to a country where they would face a real risk of relevant harm. Under the Refugee Convention, the obligation not to refoul is not absolute. It is subject broadly to two exceptions. The first of those is the Article 1F exclusion from protection of the Refugee Convention. That exclusion applies to those who have committed war crimes, crimes against humanity, serious non-political crimes abroad, and acts contrary to the purposes of the United Nations. The second exception is provided for in Article 33(2), and this concerns those who pose serious risk to the security of the host country and those who have been convicted of particularly serious crimes and therefore pose a danger to the community of the host country. As the UNHCR have said in respect of the Article 1F exclusions, their rationale is that certain acts are so grave as to render their perpetrators undeserving of international protection as refugees. The CJEU has said that its purpose is to maintain the credibility of the protection system. And as Professors Hathaway and Foster have noted, the realpolitik reason for it was that the drafters of the Refugee Convention were persuaded that if state parties were expected to admit serious criminals as refugees, they would simply not be willing to be bound by the Convention. The same is presumably true of the Article 33(2) exceptions. It would be surprising if states would have been willing to sign up to a duty not to refoul if it didn't have that exception for those who were a threat to their countries. In 1987, the UN Convention Against Torture came into force. It now has 173 state parties. Article 3 of the Torture Convention provided for an absolute non-refoulement rule in cases of torture. Although the Convention dealt also with cruel, inhumane and degrading treatments, states were careful to limit this absolute non-refoulement rule to torture. The result of this is that even if an individual falls within the scope of Article 1F or Article 33(2) of the Refugee Convention but would face a real danger of torture, they cannot be removed. It was felt by states that torture is such an absolute evil that the credibility of the international protection system would not be undermined by preventing the removal of such individuals if they faced torture. Whilst the Refugee Convention and the Torture Convention both explicitly addressed the issue of non-refoulement, the ECHR did not. It prohibits states from engaging in torture, cruel, inhumane and degrading treatment, but it says nothing about refoulement. This is not surprising, as the ECHR was drafted at the same time as the Refugee Convention and arguably was felt that those issues were best addressed by the Refugee Convention. Nonetheless, in the late 1980s, the Strasbourg Court interpreted Article 3 as prohibiting refoulement. It did so not just for torture, but for all forms of treatment contrary to Article 3, and it held that this rule was absolute. As the court put it, the conduct of the person concerned, however undesirable or dangerous, cannot be taken into account, with the consequence that the protection afforded by Article 3 is broader than that provided for in Articles 32 and 33 of the 1951 United Nations Convention relating to the status of refugees. This interpretation by the Strasbourg Court completely negates the careful balance struck by the international community with the Refugee Convention and Torture Convention. What is being posited in this amendment is that this interpretation threatens the legitimacy of international human rights law, and that conclusion by Strasbourg is the means by which that happens. The case of KM Congo provides a good illustration. KM was a police officer in the Democratic Republic of Congo. He entered the UK legally in 2012 and applied for asylum. His application was refused by the Home Secretary on the grounds that he had been involved in torture. The upper tribunal held that finding and held that he should be excluded from protection under Article 1F of the Refugee Convention. However, because of Article 3 of the ECHR, as interpreted by the Strasbourg Court, he could not be removed. There are many more cases of serious criminals and terrorists, people who are a threat to those who live in the UK, who could be deported under Article 33(2) of the Refugee Convention, but cannot due to Article 3 of the ECHR. In Sardi versus Italy, two Strasbourg judges wrote that they would not be surprised if some citizens of Europe find it difficult to understand that the court, by emphasising the absolute nature of Article 3, seems to afford more protection to the non-national applicant who has been found guilty of terrorist-related crimes than to the protection of the community as a whole from terrorist violence. Indeed, the Father of the House, were he here, would say that he suspects that the vast majority of Britons and Europeans would be baffled by that conclusion. That is also precisely the reason why the drafters of the Refugee Convention saw fit to include exceptions for criminals and terrorists. They knew that with rights come responsibilities, and that those who act in this way completely violate the social contract and cannot properly claim its protection. The interpretation Strasbourg has given has, in the view of the Father of the House, or I think at least in a way that he would like us to debate, weakened the legitimacy of the international humanitarian protection system. The amendment by the Father of the House seeks to find a solution to this problem, one that he says will restore common sense. The first step of his amendment is to put a duty on the Secretary of State through careful litigation before our courts to identify cases which could be deported under the Refugee Convention and Torture Convention, but would be blocked under the ECHR. Cases like the KM case I discussed above, he sees as exemplars of this. It then disapplies the duty on the Secretary of State to comply with the Human Rights Act in such cases. This is to ensure that the Secretary of State can proceed to deport such people, and if they want to challenge their deportation, their recourse will be to bring a case to Strasbourg. I know my honourable friend, the Father of the House, would be comfortable with putting a duty on ministers to still deport such individuals, even in the face of a Strasbourg judgment or Rule 39. But he knows that the firm commitment the government has to international law, though he also says we should ask why they would be privileging the ECHR over the Refugee Convention, means they will refuse to do so. So instead, the amendment allows the government to comply with Strasbourg, but instead requires the government to argue with Strasbourg that they are wrong to interpret Article 3 in a way which negates the provisions of Article 1F and Article 33.2 of the Refugee Convention. If Strasbourg were to apply the principle of lex specialis properly, it should conclude that it cannot be unlawful for states to rely on Article 1F and Article 33.2 of the Refugee Convention in order to deport criminals. The Father of the House, my honourable friend, would be interested in hearing from the Minister on whether they would be interested in running such an argument before the Strasbourg Court. Even if we lose in his in such efforts at being reasonable, the Father of the House feels that the amendment allows the government still to decide to comply with the flawed jurisprudence from the Strasbourg Court, but it requires that if it does so, it must be transparent with the British public and publish a report telling us who the criminals are that we could deport under the Refugee Convention, but which the Strasbourg Court's flawed interpretation of the ECHR prevents us so from doing. I will not be pressing this amendment to a vote, and I repeat again that it is not my amendment, but I look forward to hearing what the Minister has to say.
Duties to deport in accordance with the Refugee Convention.
The question is that new clause 44 be read a second time, Minister.
Thank you very much, Dr Morrison, and I have to compliment the Father of the House on his ingenious approach to the slightly different signals, as the Honourable Lady has set out, that the international conventions with their judge-made law over the years have left us with. But the amendment, the new clause, would mean that there would be a duty to remove people who are not protected by the Refugee Convention, irrespective of our obligations under the Human Rights Act and the European Convention on Human Rights as it's developed. And the Honourable Lady set out that issue extremely well. We will always seek to deport or remove those foreign nationals who pose a threat to the UK or whose behaviour is such that they're not entitled to international protection. Where the UK's obligations under the European Convention on Human Rights prevent us from doing that, we will consider granting restricted leave, sending a clear message that the person is not welcome in the UK and will be removed as soon as possible. We have introduced an amendment, the Honourable Lady will remember, to this bill, which will allow us to closely monitor people who pose a threat to the public but cannot be deported because of our obligations under domestic and international law. And the Honourable Lady will remember that that involves such things as curfews and inclusion and exclusion zones. This government is clear. Britain will unequivocally remain a member of the ECHR and work with international partners to uphold human rights and international law. Leaving would undermine protections for UK citizens and isolate Britain from its closest allies. This amendment provides a mechanism for the Secretary of State to disregard a ruling of a court or tribunal that removal from the UK will breach a migrant's human rights. That would place the UK in direct conflict with the European Court of Human Rights. The law doesn't permit us to operate with 1 foot in and 1 foot out. We're either in and we're signatories of it, or we join Russia and Belarus as people who don't accept its jurisdictions. The law doesn't permit us to operate in that way, nor can it be said that the ECHR takes precedence over the Refugee Convention. They are distinct treaties of international law that deal with different issues. It therefore would create a situation which would be wholly unworkable, and for that reason, and I know that Sir Edward will be looking at this in due course. He's had a good go. We don't think it's workable, and therefore I certainly hope that there'll be no votes to include it in the current legislation.
Is everyone content for the new clause to be withdrawn? Aye. New clause by Leave withdrawn. That concludes the consideration of all the new clauses. The final question I must put is that I do report the bill as amended to the House. Minister.
Thank you, Dr Morrison. It's at these occasions traditionally that those who shouldered the burdens under your expert guidance of this committee thank all the officials, both House officials and my own officials, for the sterling work that they've put in. To thank all members of the committee for the contributions that they've made, all of which have come from positions of principle and concern. I think we've had some robust debates over the time that we have been in committee. We've even had a little bit of fashion commentary. I think all of us will be pleased to get out of committee today, because this room is getting colder as the week goes on, and goodness knows where we would actually be if we had to come back on Thursday to finish our deliberations. So I'd like to thank all members of the committee. I hope they've enjoyed doing this bill and having these debates as much as I have. Thank you, Dr Morrison.
Thank you. The question is that I do report the bill as amended to the House. As many as are of that opinion say aye. Aye. To the contrary, no. I think the ayes have it. The ayes have it. Order, order.